welcome back to True Crime Metrix. How are you doing? So, we had an appeal the other day, rather an appellate hearing. What does that mean? It means Charlie sent one of his guys, this one in the bow tie. I never understood bow ties. I don't think I've ever worn one in my life. Maybe I should try it if I want to become an appellate attorney. Charlie Adelson sent one of his boys into the big courthouse, the fancy courthouse down the street, to talk to the panel about all the reasons why he didn't get a fair trial, why the judge was evil, and so on. So we'll have a look at those reasons. We'll have a look at the likelihood, see if we can back it up with any other resources. Then it's also Mother Donna's birthday today, February 5th. She turned 76 while being housed like a dog in jail. A dog in jail. So we don't know if she had any visits, any nice things in the mail. Maybe a special meal. Maybe one of her cellies let her have an extra half of an apple that they found. We don't know. So I figured we'd do something Donna orientated as well. Maybe jailhouse calls, Why not? Kind of ties in nicely with Charlie's appeal situation, right? Well, we will of course also listen to the state and what the state of Florida has to say about why Charlie Adelson should not get a fair trial. Whoops. A new trial. So that's probably what today's show's going to look like. I hope that's okay with everybody. Everyone good with that? David Anderson Kirk, hello. Chris Campbell, hello. Deborah, how you doing? And Ms. Pugsy, good to see you. Good to see everybody. Okay, let's hear from the bow tie. Wow. Boop. 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 Don't like the courtroom. I want it held in Judge Everett's courtroom. This is a sham. This doesn't count. I just wouldn't be comfortable in there. I suppose you're not. It's not designed to make you comfortable, is it? It's designed to help you observe power. There's a man who just mildly had his ego boosted and then got uncomfortable and ran off. Yeah, been there, man. Not exactly a packed house, is it? What have we got here? We've got what's his name? Jensen. What is it? Tom, Ted. I'm just blanking. We got Patty Wilson over there in the Love t-shirt. And is that, I think Deep Dish is at the back, maybe? I don't recognize anyone else. Apart from the photographer who's in everything. I think she's Tallahassee Democrat photographer, the girl that always has a skirt that's so short you can see all the way to home base. Tim. You know what I was thinking? I was thinking of Ted Danson. That'd be great. That'd be great if he was in the gallery, wouldn't it? Tim Jansen. Ted Danson. Okay, that's what he's called from now on. You know, I love a malapropism, don't I? Always do.
All rise. First District Court of Appeal is now in session. All who have business before this court draw near, give attention, you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. Good morning and welcome to the First District Court of Appeal. We have one case on the docket today, Charles Adelson versus State of Florida. Counsel, when you're ready, you may proceed.
Good morning.
No pressure. Oh God, you know, I don't know if I'd like being an appellate attorney. It's a different beast, isn't it? Just suddenly they're out here. You may proceed in front of all of us and the world. Just one more time. Let's just let that pressure cooker heat up.
Good morning and welcome to the First District Court of Appeal. We have one case on the docket today, Charles Adelson versus State of Florida. Counsel, when you're...
Charles Edison? What, the inventor of the light bulb? Thomas. We all know that it's Thomas.
ready, you may proceed.
Good morning. May it please the court, Michael Ufferman on behalf of the appellant, Charlie Adelson, seated with me at council table is...
Sorry. We've got a nice, brand new A5 notepad here. Look at that. It's got a yellow front cover. And also, update on the pen. We thought we could get away with a cheap Chinese copy. But we decided, it just, it wasn't good enough. We've upgraded. It's now Uniball all the way. Hey, Just Suze, thank you so much for this super sticker. Look at that. That is a fantastic super sticker. I want to put it on the screen. It's so nice. 1 second. Just want to take down the name of the attorney. Where's my super sticker? Okay, there. We'll click. Oh, look at that. That's fantastic. Thank you, Just Suze.
Co-counsel Laurel Cornell Niles. I'd like to reserve... Good morning.
Versus State of Florida. Counsel, when you're ready, you may proceed.
Good morning. May it please the court, Michael Ufferman on behalf of the appellant, Charlie...
Michael Loughborough? Is it Loughborough? Loughborough?
Adelson, seated with me at council table is co-counsel Laurel Cornell Niles. I'd like to reserve 5 minutes of my time for rebuttal.
Laurel Cornell Niles. Now that's a fucking name, isn't it? Wow. I want to change my name to Laurel Cornell Niles. Until that's on my driver's license, I have not been living a life.
So noted.
I'm hoping to focus the beginning of my time this morning on the first two claims, which are the jury selection claims, and I think they're intertwined. And then I also intend to briefly address ground three. So let me begin with the jury selection claims. Claim one concerns the trial court's failure to grant the motion for a change of venue. Claim two concerns the trial court's failure to strike the panel, and then specifically...
Whoa. It's, okay. I know he's on a time limit, but I'm trying to take notes.
And I think they're intertwined. And then I also intend to briefly address ground three. So let me begin.
I love the tactics that they use. Yeah, I've got two issues, two grounds, and I believe that they're actually intertwined. It's a good call to attention. Like it.
The jury selection claims. Claim 1 concerns the trial court's failure to grant the motion for a change of venue. Claim 2 concerns the trial court's failure to strike the panel, and then specifically, as that issue evolved, to strike the middle group of jurors 51 through 102, for reasons that I'll get into in a second. Let me begin.
Wow, way to frame a weak argument. What have we got? You didn't change the venue. Amazing. All the people in this area know that I did it. So I don't want to ask them. I want to go to somewhere where they love rich white dentists. Where is that place? Well, how about Miami? I don't know. Change of venue, okay. Yawn. And then failure to strike the middle, what was the word? Middle panel of pool, jury, the middle group. The middle group, failure to strike middle group of jurors. Strike middle group jurors. Okay.
And with the change of venue argument, the numbers in this case are pretty striking. We know that of the 130 jurors who were questioned individually, and that's the way this process went. The judge began jury selection by individually questioning jurors in groups of 50. There were 3 total groups that were ultimately questioned to determine whether or not they've formed an opinion about the case and whether or not they've been exposed to pretrial publicity. Of the 130 that were questioned, 54 said that they had formed an opinion regarding innocence or guilt, and 53 of those had formed the opinion that my client was guilty.
And they were excused for cause,
They all
correct?
were.
All right, so let's start a little bit about the procedure that the rules require before those interview questions are even asked. Why don't you address, the rule requires a written motion, an affidavit, and a good faith statement, correct?
Yes, Your Honor.
All right, and that didn't happen here.
No, Your Honor.
And what type?
Oh, slow down, lady, while we learn, please.
An opinion regarding innocence
The
or
rule requires
guilt, and 53 of those had formed the opinion that my client was guilty.
And they were excused for cause,
They all
correct?
were.
All right, so let's start a little bit about the procedure that the rules require before those interview questions are even asked. Why don't you address, the rule requires a written motion, an affidavit,
written motion, affidavit,
and a good faith statement, correct?
Yes.
good faith statement. This is the thing. This is the thing about the system that I'm surprised that it's still allowed to be based on good faith, right? I mean, with all the tech, with all the super tech, we're talking about putting space aliens on Mars, and we're still dependent on good faith statements. I can be neutral. No. In good faith, I can be totally neutral. I mean, if it were me, I would have done anything to be on that goddamn jury for Charlie or Donna or anyone else, right? I'd have been like, yeah, I don't know anything about the case. Charlie who? Charlie Watts? Yeah. What's on appeal? No. I'd have done anything, right? You gotta think that all those jurors, how many was it total? 300 or so that it could have been. There's probably a few people like me that would have just said, yeah, don't know about the case, but I'm super passionate about it and I love it. And I do have a vested interest, but it's the right one. So I want to be on the jury in good faith. There's just so much opportunity for things to slip through the net when it's based on good faith statements. I'm just surprised that we're still hawking that routine.
Yes, Your Honor.
All right, that didn't happen here.
No, Your Honor.
And what type of things would we have seen in an affidavit before any jurors were interviewed?
I don't know, and my response to that is, and I understand that I'm attacking the rule and it's a requirement, although there's certainly case law that says that if a motion in any context is made orally, and if there's a component within our criminal procedure rules that requires it to be written, if it would be a useless gesture for such a motion to be submitted in writing when it's been thoroughly discussed and ruled upon orally, then that's not required. And I think that, again, specifically applies to this type of case. We know the Florida Supreme Court has been very clear that change of venue claims almost always need to be considered during jury selection, that a judge is not going to grant a change of venue claim pre-trial.
Sure, but one of your arguments is that the Tallahassee community, almost 300,000 people, was so tainted by what you characterize as pervasive media that there could be no jury selected that would be impartial. And wouldn't affidavits have shown, for instance, that what types of media that the citizens of Tallahassee in this community were consuming? And you definitely see in the record the local sources, national sources. You make the argument that this isn't like the 1994 trial of Danny Rawling in 1994, where people would watch Dan Rather or Tom Brokaw, and I think that's right, but wouldn't the affidavits also have shown that maybe consumers curate their media differently? We saw in this transcript there were many consumers of media who said, I'll give some examples. They don't watch television. I turned off my propaganda box 3 years ago. I don't read the paper. That's for rapping mullet. Very rarely do I watch the news. And so you see a lot of behavior in this typical kind of Tallahassee community that's different than 1994. Couldn't you have shown those things in an affidavit before you interviewed a single juror?
Clearly, the rule says that should have been done, and I'm not disputing that it should have been done, but I submit that it was established by the record as you just indicated. The record very clearly shows the way that the 130 jurors that we're talking about consumed their information about this case. And it's not just, contrary to what happened in 1994, what was happening in the 90s, it's not just the print media. Clearly the Tallahassee Democrat covered this case extensively. It's not just the local news. Clearly the local news covered this case extensively, but unlike the...
Just say it, man. Just say it. It's True Crime Metrix and all of his followers that have ruined your client's chances of a fair trial. You're blaming me. Just say it. I can take it, No, I mean, it's not just me, is it? I'm talking about podcasts and YouTubers. That's what he's really... It's not 1994, okay? We've got more than print news media now. We've got something called the internet, and there's all these people on it that know the truth, and they're telling the world. We can't allow this to happen.
90s. Now we have several jurors saying that they're getting their information from cable news networks, Court TV, shows
YouTube, Court TV, 2020, Over My Dead Body podcast, The Preston Scott Show.
Been thinking about going over the Over My Dead Body podcast as well, and just talking about it, right? Because it does, personally for me, I find it a little bit... No, I mean, it's good. It's good. It's good. It's just there's something about the presentation that that makes me fall asleep. But maybe that's the idea. I don't know what ASMR is, but people keep talking about it, and I think it's those videos where it's like that are supposed to put you to sleep. It's like a bedtime story, but with facts. Yeah, so maybe we're going to check that out. Maybe today, maybe tomorrow.
Tallahassee Democrat, but what you don't have in this record is how many times those exposures happened, whether they were biased or not, whether there were some...
We don't have a number big enough, lady. I mean, what do you think the number is, huh? If you took all the videos, all on the internet about Charlie Adelson's guilt, how many would that be? How many hours? How many watch hours would that be? Billions. At least, well, absolutely billions. Probably not trillions. But 100% billions. I'll tell you what it is just from me. Hang on, let me get the number.
Broadcasts or podcasts that, in fact, argued that your client was innocent. So we don't have the content of that.
There could have been podcasts that said that your client was not guilty. Hey, lady, have you been online? Why does that need to be in an affidavit? No, there's not a single video. There's some about Wendy, just from that one guy who's writing a book. Oh, what was his name? I always forget. It's Thomas something, I don't know. Someone Thomas, that's it, something Thomas. Yeah, but with Charlie, I don't think I've heard even one crazy freak like that, like Mr. Thomas, that's saying, set him free. She's like, well, you didn't tell us what the media said, so it could have been good. It could have been biased for your client's interests. What? This is the other thing. Why can't they just pull up a screen, go to YouTube, type in True Crime Metrix, and watch one of my videos in the court?
To show how that would have influenced the veneer, correct?
We do not have that from affidavits pre-trial showing the things that you just mentioned, but we do have that in the record based on the answers that the jurors gave. And again, when we are talking about a little over 40%, that's a huge number. In the Murphy case, I believe...
We're talking a little over 40%. That's a huge number. Yeah, we can tell from the way that you said 40%.
It was right around 25%, and in that case, the court said that's not enough. Here, we are at 40%. So when you talk about 40%, when you talk about the judge making a finding when granting the protective order pre-trial that...
I thought he said when you talk about the judge baking a finding. He's baking something, and it's a whole tray of flapjacks. When you talk about the judge baking a finding, when you talk about the judge finding something and then immediately baking it, and covering it in powdered sugar, baking news, Judge Everett news.
Tallahassee is in fact a small community. When you talk about this case has been permeating Tallahassee media sources for almost a decade at the time of this trial. When you talk about there was 3 previous prosecutions, one of which resulted in a mistrial and a subsequent trial just a year before my client's trial.
Sure, but why don't we talk about what the Florida Supreme Court says when there's pervasive media? Certainly no one would argue that there wasn't pervasive media in the Danny Rowland case, right?
Correct.
We're talking about 5 murders, college town, again, maybe a small community as you would describe it, perhaps.
Sure.
So with that, since that case, in the Ellerby case, the Armstrong case, the court has said that it's not enough to show that media was pervasive. It was, could the juror be impartial? Every single juror seated in this case said that no matter what contact, many of them had.
Check it out. What is this? Christopher Biddell. Ooh, 1848. Is a brand new exclusive Metrix member. Welcome to the team. That's a great way to support, and yeah. And plus, you get what is that cool thing that happens? Oh look, you can put a picture of a dog. Or this, boom. Sushi, boom. A Prius, boom. Banana bread, boom.
No contact with media or information, that they could be impartial. Isn't that right?
That's correct.
All right, so specifically, I'd like you to address the Armstrong case. The state raised it in the answer brief, and you did not address it in your reply brief. The Armstrong case, the Florida Supreme Court, and this is 24 years after the Manning case that you cited in your case.
Miss Myers, welcome back. Hello, Miss Myers.
They said that if you don't renew your objection to the jury before the jury is impaneled, in fact, your client accepted this jury, that you have waived it and we may not reach that issue. What do we do with Armstrong?
So two responses to that, three actually. Just quickly regarding my client accepting it. I don't know that my client accepting it.
I feel like we need to slow this down to half speed. Just to, it's... These judges, they don't have time to, the time is precious, right? So it's going too quick for me to fucking wrap my head around everything. Let's just go back a minute.
With that, since that case, in the Ellerby case, the Armstrong case, the court has said that it's not enough to show that media was pervasive. It was, could the juror be impartial?
Not enough to show that media is pervasive. Could the juror be impartial? Again, I mean, we're relying and basing that on nothing other than their word. And I would lie my ass off to get on that fucking jury, right? Never heard of the case. Nope, don't know. Metrix? Who's that? Don't know who that is, sorry. I can be impartial. You have my word.
Single juror seated in this case said that no matter what contact, many of them had no contact with media or information, that they could be impartial. Isn't that right?
That's correct.
All right, so specifically, I'd like you to address the Armstrong case. The state raised it in the answer brief, and you did not address it in your reply brief. The Armstrong case, the Florida Supreme Court, and this is 24 years after the Manning case that you cited in your case, they said that if you don't renew your...
So David Anderson Kirk says, deep dive guy, baroscope guy, isn't it Veroscope? And various others have asserted that social media influence is not a thing in court proceedings. What does that mean? I think it is. I mean, it obviously is. Right? It's information. And,
Your objection to the jury before the jury is impaneled, in fact, your client accepted this jury, that you have waived it and we may not reach that issue. What do we do with Armstrong?
So two responses to that, three actually. Just quickly regarding my client accepting it. I don't know that my client accepting it matters much. I think the concern is did defense counsel renew the objection? The state made an issue out of that. And if you look at the question asked of my client at the conclusion of jury selection, the judge literally says, you have no choice but to accept because you have no strikes left.
But was there an objection?
No,
was there an objection?
I understand. But again, to that, I'm just responding to the concern. I understand the state raised it, and that's probably why you're saying it. But my client accepting the jury is irrelevant to this matter. The question is, did defense counsel renew the objection? I acknowledge that generally is what's required for any type of jury selection claim. However, Manning...
So the fact that Charlie said, yeah, I'm fine with the jury, doesn't count? Why not? Why? You need to tell us why, Bowtie.
Is specifically a case where we know from the dissenting opinion the request to change venue was not renewed.
But I'm going to repeat, Manning was decided 24 years before Armstrong in 2003, where the Supreme Court specifically said the failure to renew is waiver of the claim.
I understand.
That's precedent that's binding on this court, is it not?
The court doesn't, we're all familiar with the principle that a court doesn't overrule itself sub silentio. The court has not specifically said Manning's no longer a good law. That being said, I rely upon Manning because it was ultimately reached consistent with what I think the U.S. Supreme Court has said is an appellate court's burden to go through the record in one of these cases to determine if there's a change of venue issue. But beyond that, I will acknowledge that at the very least, to the extent that this court finds that it's not preserved because it was not renewed, then the question is it fundamental error? And I submit that based on the facts of this case, we do meet the fundamental error standard. In the Smith case just 4 years ago, the Florida Supreme Court specifically said that the failure to preserve a change of venue claim can nevertheless be reviewed under the fundamental
Well, my
error
understanding is, the reason we have this very, very unusual requirement for, a renewal of an objection is not just simply, it's not just Simon Says, just, you got to do it twice or else. It's that it is possible that the defense is happy with the jury. It's generally in the challenge context, when you challenge a juror and they want to see whether you renew that challenge, that you are in fact satisfied with the jury. So I don't know if you can say that it's a fundamental error.
Hello, Samara, and hello, Piebird. And Cindy, Daphne, hello. God, I keep forgetting to put on that alert sound thing to tell us when people put a little coffee in our cup. What do you think? Do we need a new soundbite, or is the classic still what people love?
Fucking A, bro. I'm gonna fucking fuck up whoever the fuck is fucking with me.
I don't know. Does that say 2026? Does that say new Metrix? Or, maybe we need everything new. A new intro, a new outro, a new, what do you call it? The thing in the middle. And a new coffee alert. But, for old time's sake, let's just hear it one more time.
Fucking A, bro. I'm gonna fucking fuck up whoever the fuck is fucking with me.
You gotta love her.
Error issue, if in fact the defense was satisfied with the issue. Now, I did believe when I saw Armstrong, it's like, wait a minute, it's not what happened in Joyner. It's not a cause challenge, it's change of venue.
Correct.
But when you read Armstrong, it's very clear. First of all, it says that
So we should write that down. Armstrong, and what was it? Joyner. Joiners tend to have strong arms. Or any carpenter. If there's another case citation called Carpenter,
a change of venue motion is premature until you actually attempt to select a jury. What
Correct.
that says to me is a change of venue is a jury selection issue.
Sure.
And what I draw from that is that Justice Judge
Cindy says appeal judges or appellate, appeal judges and lawyers are pretty genius. Yeah. So what do you think about Judge Everett not making the cut? No one's going to take away his genius, that brain. He's got a brain the size of Wisconsin. The only concern would be, could he be swayed by a well-placed tray of sweets? And they probably put that to the test in the final stages of his interview. And I think we all know that he failed miserably. Crumbs all over the floor, along with his dreams of becoming an appellate judge.
Rowe is saying, if you in fact are able to find jurors who swear that they are untainted, then I don't know if there is in fact a change of jury issue. It very well may be that the defense thinks, okay, I found untainted jurors. I don't really have any reason to continue with the change of venue objection. So that raises two things. Number one, whether the fact that you have untainted jurors overcomes the fact that the community may have had a low level of taint. And number two, the suggestion that it's fundamental error when the whole point of the objection is that the defendant is satisfied, which I don't think a fundamental error claim can overcome.
So a couple of responses to that. Again, the Smith case is 2021, and it's specifically page 28 of the Florida Supreme Court's opinion, and they clearly went on to address the claim for the change of venue motion, despite the fact that it was not preserved, and they did so under the fundamental error standard.
You know what? I am actually going to see if this is tolerable on a slightly slower speed, because it's like a fucking test. It's like a damn test. We shouldn't swear so much. It's like a goddamn test.
And so, I'll quote from the case.
But isn't there a difference between preservation and waiver?
Sure, well, yes, but so if we're going to waiver, and now if you're addressing what my client said at the conclusion of jury selection, that's no waiver on my client's part when the judge specifically told him, you have no choice.
I guess perhaps I should just read Armstrong again, because Armstrong says a motion for change of venue should be renewed at the conclusion of jury selection or be considered waived. So it is the failure to object that is the waiver in this context. I mean, do you read it any differently than I do?
If that were the case, then Smith in 2021 would be wrong.
Blacksmiths have really strong arms too, right? That's what they say. They say, I hear you have the arm of a blacksmith. You know, from, what is it? Great Expectations. Yeah. And then Pip gets all worried, doesn't he? He's like, oh shit, they're going to know that I'm a blacksmith. But he's just talking about how he's good at rowing.
And Smith obviously is more current and specifically says that because the issue was not preserved, because it was not renewed at the conclusion of the jury selection proceeding, we review this claim for fundamental error. So I submit to you, again, this court has the ability to review the claim. Smith from the Florida Supreme Court very recently has said for at least a change of venue claim. It may be different for a peremptory challenge.
Anyone else think that color is great on Patty? Just red. Just straight up red.
The failure to grant a cause challenge, but when it comes to change of venue, the Florida Supreme Court has specifically said it can be reviewed.
A custom alert, David Anderson Kirk. That sounds great. I'd love to see what you could do there. Something short, something friendly, and something Metrix.
For fundamental error. And I guess going back to Manning, and I understand the time difference, but Manning would be a great example of that. You literally have the attorney in Manning saying at the conclusion of jury selection, I believe we picked a fair and impartial jury. And I submit that there's no jurist in this state that would review the facts and reach a conclusion, unlike what the Florida Supreme Court did, that there's no way that venue could have been fair within Columbia County in that case. So that's exactly why these claims can still be reviewed for fundamental error.
Just generally speaking, you know, normally when we talk fundamental error, it's because that an error wasn't preserved below. Can
Correct.
Fundamental error be affirmatively waived?
If defense counsel had said, if the question, rather than to Mr. Adelson, do you accept this jury, and let me point out you have no choice but to accept the jury, but answer me anyways, do you accept this jury? If it had been defense counsel, do you previously raised some objections? Do you now no longer renew those objections and accept this jury? If that would be the case, I would have no ability to make an argument in front of you today. That would be waiver. That's not at all what we have in this record. I think the fact—
It sounds to me like you're going up a 3850 avenue, but let me ask you this question. Is Armstrong's a 3850 appeal?
Correct.
The other cases we're talking about.
3850. You see, that's the stuff that still goes over my head. And they say it like we're all supposed to know what the fuck that means. It sounds like you're going up a 3850 avenue here. Well, that was my thought as well, straight away, Judge. Definitely a 3850. Not a 3849, not a 3851. It was definitely a 3850. I knew immediately.
About earlier were direct appeals. Is
Correct.
that distinguishable?
Perhaps. I mean, again, a lot of times when the Florida Supreme Court considers 3850s, they also consider 9.141s in the context of failure to raise issues.
Debbie Gibby says, hi all, and Metrix, yes to the new coffee alert, because I can't listen to you when my daycare kids are up. So what are you saying, that my show is not appropriate for the 3 to 6s? I thought that was my target community audience. Age 3 and up. There's a warning. No, we are adapting, going through changes. So yeah. I mean, maybe one day we won't swear at all. How about that? We'll double our audience. Those 3 to 6s, it's a whole just wealth of a community that we're not tapping into. The daycare crowd, that's what I want.
Issues on direct appeal, and that's also the way, in Hilton at least, that the ways these claims are being raised. But again, in a direct appeal claim, in a direct appeal, the issue is it preserved? If it's not, can it be reviewed for fundamental error? I submit that there are some things that cannot be. Generally speaking, the failure to renew a cause challenge is not something that's going to be reviewed for fundamental error. The court's been clear about that. And if there is a specific waiver on the record, we don't have that here, then no, you wouldn't be able to review it for fundamental error. Waiver trumps fundamental error. We don't have a waiver here, and I submit that fundamental error is still the standard.
But surely you're not arguing that now a trial judge has to, who's represented, a defendant's represented, now a trial judge has to look to the defendant who's represented by counsel to say, do you individually accept a jury?
I have no idea why the judge did that in this case.
Well, I think the oven timer went off and he just said whatever to get out of the room.
But are you promoting a bifurcated question by a trial judge to counsel and a defendant?
I think in the context that the judge is asking the question in this case is it fairly could be construed as, do you have any other strikes? And that's why, and every time that question was being asked, there was a strike, because there were back strikes in this case. So ultimately, when he just asked the same question he'd been asking up until that point, the question was, do you accept this jury, i.e., do you have any other strikes? And I guess let me throw out there, you have no other strikes, so you have no choice but to accept the jury. That's why it's being said here. Again, I acknowledge it's incumbent upon defense counsel to jump in and specifically say, we renew the objection, but if that's not done, it's still reviewed for fundamental error. I see that I'm getting in my rebuttal time. I would like to make a couple other quick points about the merits.
I'm going to extend your time by 5 minutes. I'll do the same thing for the state.
Thank you.
I don't think the state makes use of that. From what I remember, he flies through his presentation. He just basically walks up and says, uphold.
Appreciate that. I do need to address, so we have, and I've already talked about this, the almost 40 or a little more than 40%. We have the Tallahassee community. We have the different ways that social media infects jurors in a community now. But we have more than that in this case.
Infects. The way that social media infects jurors in the community. Those podcasts. You couldn't have used a less biased word? Biased word? No.
In Patton, the U.S. Supreme Court said exactly this: adverse pretrial publicity can create such a presumption of prejudice in the community that the jurors' claims that they can be impartial should not be believed. The U.S. Supreme Court is saying that
And they're saying that, and they probably are.
Yeah, I agree. I think I agree. I need to hear that again.
Patton, the U.S. Supreme Court said exactly this.
The U.S. Supreme Court said exactly this. What is it?
Adverse pretrial publicity can create such a presumption of prejudice in the community.
Adverse pre-trial publicity can create such a presumption of prejudice
That the jurors' claims that they can be impartial should not be believed. The U.S.
I do need to write that down. I'm sorry if that's annoying, but what was it?
have more than that in this case. In Patton, the U.S. Supreme Court said exactly this: adverse pretrial publicity can create
Adverse pre-trial publicity can create
such a presumption of prejudice.
Such a presumption of prejudice. Fuck. I'm not really writing that down. It's more like squiggles that will be clues to what the word is later. Prejudice. Such a presumption of prejudice that
In the community, that the jurors' claims
in the community that the jurors' claims that they can be impartial should not be believed. Yeah, I'm just writing that down because I want to look that up and have a look at the wider issue there of social media. You know, you better believe that we're going to see a lot of that in Courtney Clenny's trial coming up in April, right? All that bad social media of her screaming in the apartment, "Find my phone and fucking charge it!" What the fuck? What on earth? My golly good gosh, what on earth? My golly good gosh. I mean, yeah, it's just, what is up with that? She should be sent to prison just for screaming.
that they can be impartial should not be believed. The U.S. Supreme Court is saying that
And they're saying that, and they probably are saying that on a record where there was a record that the media exposure was indeed adverse. And again, we can't presume that,
Let
can we?
me go further with that, Your Honor. What they're saying is there could be such intense media influence in a case that we may not even believe.
Poison influence, come on. It's an infection, remember? There could be such intense, evil, media poison influence, false info.
Believe what the jurors are saying. And if I came to you with no evidence in the record and said, that's what we have here, you would say, Mr. Ufferman, you're speculating. We have 2 instances where jurors lied directly.
I do kind of like this attorney, but what he's doing right here is straight out of Daniel Rashbaum's playbook, right? That lean podium point, the leaning podium point. Gotta write that down. That's a tactic. The leaning podium point. And the kind of almost whisper of of this discovery that he's made. We have 2 judges that have said that about. Love it, love it, love it.
In a case that we may not even believe what the jurors are saying. And if I came to you with no evidence in the record and said that's what we...
No doubt about it. Real soon, in time, we're going to see people saying, get rid of the fucking jury system. It's probably already happening. But, you know, I think that's going to really start to take shape. We the people, or we don't need people, we've got AI, so just listen to him.
have here, you would say, Mr. Ufferman, you're speculating. We have 2 instances where jurors lied directly to the trial court, asked point
So are we
blank.
supposed to just...
But he said his name there again, doesn't it? It's not Loughborough, it's, what was it? Ruthman. We'll find him. Ruthman. He's a little rough around the edges. That's why he has to wear the bow tie. Because he's a roughman.
assess the credibility of these jurors? Is that what an appellate court is to do under this theory?
No, but what we have in this record...
Appellate judges, they're so funny, aren't they? Because they're obviously extremely just expert knowledge. I mean, top of the line, top of the field, whatever. They're clearly, but they always do this thing where they welcome you to explain to them in the plainest terms possible, which is actually how you get things done, isn't it? It's fascinating.
Is 2 instances where jurors were specifically asked, have you formed an opinion about guilt and...
Imagine what fake Ben would do in an appellate hearing. Well, the seamless guidelines that I effortlessly put forward into my miraculous creation. I still find that fucking hilarious. You know? Anyway.
in this case, or have you posted anything on social media about this case? In both instances, the jurors said no. In one case, thanks to good defense counsel, good lawyering, they had a couple of posts from that juror and presented them to the trial court where that juror had said that the parents of Professor Markell should assist in killing Mr. Garcia, and then went further when my client was charged and said,
Look at leopard print in the front row there. She's finding this hilarious. What was that? Killing Mr. Garcia. The parents. You see, it's a little hard to take in, isn't it?
Anything on social media about this case. In both instances, the jurors said no. In one case, thanks to good defense counsel, good lawyering, they had a couple of posts from that juror and presented them to the trial court where that juror had...
So he's supporting the good lawyering of Daniel Rashbaum, but also saying that in acting as Charlie Adelson's attorney, he was operating under a conflict. I mean, would that be good lawyering? Do people, is that what it's going to say on Daniel Rashbaum's tombstone? Or maybe not tombstone. How about engraved into the marble atrium of his 3-story What is the name of his type of house? I don't know. Mansion. Engraved into his marble mansion is the words, Daniel Rashbaum, the good lawyer.
It said that the parents of Professor Markel should assist in killing Mr. Garcia, and then went further when my client was charged and said, surprise, surprise, Mr. Adelson is charged. But the worst one is by far the next one. Mr. T is how I referred to him, as the first initial of his last name. Mr. T.
Mr. T? There's 26 letters in the alphabet, and it had to be Mr. T. We're going to put him on the screen. Dun 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 dun. Dun dun dun. Dun 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 dun. Dun 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 dun. I want that as the theme tune. The A-Team. Where's a good old picture of Mr. T? Let's bring him up. What about... Yeah, that'll do. Bum, ba, bum. Dun, dun, dun. Do, 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 do. Do, 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 do. Classic. David Anderson, Kirk, I gotta send you something later. I gotta dig that out and send it to David. Let me write down spaced Mr. T club scene. Send to D-A-K. That's why we have a notebook. All right, where is our good friend and colleague, Mr. T? Boom. Boom. Too big.
Stood in front of the trial court and when asked, have you formed an opinion about whether or not this defendant is guilty? He point blank told the court, no. Lo and behold, 2 jurors later, Miss M comes in and by happenstance is asked the question, has anyone been discussing this case amongst the jurors? Oh, why, yes. In fact, that gentleman that was just excused with the glasses, what's he been saying? He's been going around telling other jurors that Mr. Adelson is guilty.
And both of
Yeah, well, he wasn't on the jury.
those jurors were excused for cause, were they not?
Yes, but statistically, if those two, it's very hard to prove someone's lying. Usually you rely upon some.
So what sense does that make? His issue is that in the, I don't remember the exact number, was it 300, was it 150? I think they start off with 300, then they take that to 150, then separate into 3 groups of 50, whatever it is. It was a load of people from the local community that are going to be potentially on the jury. And he's saying that one of those people was in those, where they all meet in a back room or whatever, and he was going around saying, oh, he's guilty. So what happens is the court says, well, you've got an opinion, you've proven you have an opinion, you can't be on the jury, and then that's that. And then the rest of the people are vetted to see if if they've got an opinion, and blah, 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 blah. And he's saying, well, you can't allow that to happen. So how do you safeguard against it then? You've got to have some sort of pre-screening thing before you bring them in to be screened? I mean, why don't we just separate them all into, like, cubicles and starve them for 30 days and then ask questions? That's the only way that it can be done reliably. No bread, no water, no food, no nothing. No sunlight. It's an impossible ask, and the fact that these two issues, at the core of the argument is the judge didn't allow a change of venue, and there was a failure to strike the middle group of jurors with this toxic individual member of the public who came in with an opinion. That's it. I mean, presumably, this has cost a lot of money. It's taken a long time. People have been working, and they've been moving towards this date to come in here to the appellate court and speak to the panel and say, this is why we want a new trial. And the two issues that they've brought to that are nothing. I mean, really, the most basic, thought-lacking non-issues that you could come up with. I was expecting for a team of crack investigators to pick through the records, to find dirt on the prosecutor, something like newsworthy, but it's just come down to, well, he didn't change the venue, and the jury was influenced by poison media. That's it. I think he mentions at some point that if he's not successful, that he's going to come back with something else. Well, why not bring that now? Can't we get this done in a day? This is a lot of time the court has to spend on this. It's not fair to the judges. They've got what do judges do in their downtime? They've got tennis courts to build, and I don't know, what else would they build? The sunken pool in the West Wing.
Luck or some good lawyering with coming up with the post. So we know that one juror reported the other juror, and that's how we know that juror was lying.
And then being careful, defense counsel was offered the opportunity to review the tapes of the jury assembly room to see what comments were made, what are the reactions of the other jury members, and defense counsel said, no, I don't want to see it.
But here's
I know I don't want to see that. You see, that's the first time I remember hearing that. So defense counsel, Rashbaum, for Charlie's trial, was offered the opportunity, hey, do you want to see the video with audio of the jury assembly room, that's what it's called, and review it? I mean, that would have been priceless. That would be like, I didn't even know that was allowed. That would be the first thing I would want to see. I mean, what better way to get a feel for jury members, potential jury members? So you know who to pick, who to blackball. I mean, yes, show me the tapes. Let's have a look at the jurors in their normal habitat, when they're being themselves, when they're listening to Judge Everett and saying, being questioned all by the prosecutor and listening to a presentation from Georgia Kaplan. They're not themselves. There's the kind of what is the word? There's the almost pressure or responsibility. There's an etiquette There's a way to behave in a formal setting, and most people get that and want to do their best, right? There's a pressure. People get nervous when a prosecutor is asking them questions, even as a jury member, right? And a judge, forget it. Especially when he's the size of a white rhino. Don't get in his way when the bell rings on the oven.
Here's the problem with that. And going to the second claim now. The second claim is a very specific, easy fix. We know for the second group of 50 jurors, 51 through 102, problems were happening. We know about halfway through jury selection, it's reported, number one, that jurors have not followed the judge's direct.
Boom. Very nice. Look at that. Spill the crime tea. Got us 10 cups. 10 cups of coffees on the buy me a coffee thing there. Spill the crime tea says, supporting my favorite gaslighting English. Oh, and then there's an expletive that we cannot repeat because our new audience is the 3 to 6s, the daycare community. The daycare community. Yeah, well, thank you very much, Spill, and we appreciate it. buymeacoffee.com/True Crime Metrix. Links in the description. But if you hate coffee, if anybody hates coffee and says, I can't even think about coffee right now, PayPal is also a fantastic coffee-free way to support the channel, which is always appreciated. Thank you so much, Spill, and to everybody else. Also, leave a like on the video, subscribe, share, leave a comment, and just love us. Just love us.
So much so that the judge, when he heard about this after 2 of the jurors reporting that the jurors have been talking about the case, goes out and admonishes those jurors pretty sternly, do not talk about this case. But we also know...
But the problem is the content of those communications. And they were like this. High-profile case. It's the Charlie Adelson case. It's the Dan Markell case. Which of the... And that he's guilty.
This is a good question. Sandra, X's and O's, says, what is Josh Dubin's mansion going to say? We just want 3 to 5 words. Something about the rich and desperate. I mean, I just love that guy's business model. What's your business model? Inventing a price? just naming a number, a big one. That's my model. Who's your client? Well, you know, people with no options left, that believe that money can buy them out of anything, and then I relieve them of their cash. That's what it says. Josh Dubin, relieving you of cash. I don't know, something about his business model. That's what I'd want it to say.
But again, the trial court offered your client the opportunity, the defense counsel, go listen to the recordings in the assembly room and you can bring back some statements that would in fact taint the jury. How did these statements taint the jury?
We have 4 statements, right?
Right.
So we have one where a juror said, we've been talking about it all day, is literally the quote. We have another where there's some pretty...
Talking about it, I mean content. Let's get to the content.
Talking about...
Whoa. Hey, I just didn't read that word, and then the judge said it.
We've been talking about it all day is literally the quote. We have another where there's some pretty...
Talking about it, I mean, content. Let's get to the content.
Talking about the case all day.
Content, right.
Again, but you could have questioned those jurors to get specific information on what content tainted the jury.
Okay, that's one juror. A second juror then said that there had been a lot of talk about he's a professor at the law school and revealing a lot of the facts about the case. There was a divorce going on between the professor and the wife, but the two that are far the most concerning are the two jurors that specifically went back, a male and a female, the one with the glasses and then an older female that went back and told the other jurors he's guilty. In fact, if you look at Juror C on page 2581, you have, coincidentally, when she's asked, after she reports that she's heard that this female juror is saying that he's guilty, oh, what's your opinion? I think he's guilty too. This is influencing the entire, that set of the panel. So
How did these statements taint the jury? And then, he's got to think about that one, hasn't he?
The entire, that set of the panel. So let me come back to why I think this was an easy fix. There was 3 groups of 50. It was clear 8 of the jurors that sat on the jury came from this middle group, 51 to 102. At the midway point, the judge admonished the jurors to no longer talk about the case again, and the judge said from this point forward, every juror, we should ask them, have you been discussing the case? Of those 8 jurors that came from the middle group, 4 preceded those 2 things. So for those 4 jurors, we have no, and I can quickly tell you the page numbers regarding those. I have the names, I apologize. I will say them. It's Brazos, 2467, it's Kraft, 2497, Milne, 2514, Hawley, 2528. Those 4 jurors were all exposed to
somebody saying, I think that the defendant is guilty.
Yes, multiple times.
Okay, so they rendered that, so you have jurors who probably shouldn't be serving and didn't serve, is my understanding.
How many other were influenced by that?
Expressing their opinion that the person was guilty, but don't we typically, we're going to strike a panel or require the striking of a panel when facts come in that would otherwise not be admissible. Isn't that the typical standard for striking a veneer?
Strike 50 jurors. Just those 50. The clerk actually
That's fine,
said.
but the reason for it isn't that somebody has rendered an opinion as to the guilt of the defendant, it's whether they've been exposed to facts that would facts about the case that would otherwise have been inadmissible.
Oh, I don't agree with that, Your Honor. Jurors constantly saying, when they've been told not to talk about the case, talking about the case and saying he's guilty, and being exposed to that when you already have all of the social media presence that's involved in this case, that's improper. And again, the fix was easy. When they weren't sure in the 3rd group of 50 whether or not they were going to finish, the clerk said, we have another group of 50 downstairs. How easy would it have been for the judge to say, wow, I mean, he was bad, you could tell. I'm frustrated. They're not following my directions. They're lying.
Couldn't we have sidestepped some of this speculation if the tape of the jury assembly room had been reviewed and then some content specifics argued?
Yeah, but would Daniel Rashbaum been able to bill for that is the real question. I mean, how many hours would that take? You want me to sit and watch a video of 50 fucking Tallahassee residents talking shit to each other for 7 hours? Well, maybe Josh Dubin will do it.
I think it's
But it's going to cost $1 million.
clear that this 50 was tainted. And if you go back to the Manning case, what the Florida Supreme Court said that every reasonable step should be taken to preserve a defendant's trial by an impartial jury. And to this end, if there is a reasonable basis shown, the court should take action. There's, without question, a reasonable basis. We have one juror that said, you living in Tallahassee, you'd have to be under a rock to know about this case. Another juror said the impact of this
To not know about this case.
had on me, when you hear about this, it sticks with you. We have so much about this case, but then when you boil it down to that middle 50, and we know that there's not one, not two, 4 different jurors that
And I don't agree with that either. You know, if you were, you know, of a certain age, what would that age be? I don't know, 25. Even an 18-year-old kid, you know, in 2014, would you really have paid any fucking attention to this? I don't know, maybe. But what about people what about people that were 8 years old in 2014 that could now be serving on the jury? I mean, what would they know? You have to take all the people that are alive and then separate those into groups. And if they like true crime, they can't come.
is disclosed that they've been talking about the case, and it's getting the judge frustrated. He has to re-admonish them, but he doesn't go back and question the ones that have already been questioned about.
See, the judge was frustrated. The judge was having low blood sugar, okay? He wasn't worried about the, you know, we just need to get him a bucket of custard and he'll be sat.
About whether or not they've heard discussions from other jurors, and 4 of those jurors who were never questioned ultimately sat on this jury. That's a reasonable basis for the judge to have taken the easy step. You're right, at this point I'm frustrated. They're not following my instructions. 51 through 102, they're done. Let's bring up the next 50. I will be very clear going forward. He was. And if we need to go to the 4th 50, we will. That's what should have been done, and because of that, my client didn't get a fair trial. I'll reserve my last minute for rebuttal. Thank you.
And
I did quite like Mr. Was it Rothman or Rutherford? Or Loughborough? We may never know the truth, but I did quite like him. You know, in a way, his style. I mean, shit points, but is that his fault? Probably not.
And I will extend you an additional 3 minutes, and the same.
God, she just hands out these extensions. I mean, they don't even have to ask in this court. It's like, yeah, I'm going to give you an extra 5. Oh, I'll give you an extra 3 for closing. I'll give the same to the state. No problem.
For the state, so you'll have a total of 8 extra minutes.
And hey there, Kosher Style. How you doing? Where's our fantastic Kosher Style merch? Love that merch. Links in the description for the merch. The Metrix merch.
May it please the court. My name is Charlie Lee. I work for the Attorney General's office, and I represent the state of Florida in this case. I'd like to start out with the questions that judges here have asked today. One thing I do want to clear up is the preservation issue that Mr. Adelson claims in Manning in his reply brief. He talks about that in that case, the attorney below never filed a written motion, didn't renew his objection to the jury or anything like that. Those facts come from the dissent in Manning. The three justices of the Florida Supreme Court who felt that Manning should not have his conviction overturned, who felt he did get a fair trial, noted that his attorney affirmatively accepted the jury. Now, from Manning, we've come to Armstrong. And Armstrong is backed up by all the cases where we have Batson challenges. If someone
Bats and challenges. This guy's got a bit of a different style. He's a bit of a more slower speaker naturally. Do we really need to be on 0.75 speed? Maybe.
files a Batson challenge saying they didn't have a fair jury because of the demographic makeup of their jury. If they affirmatively accept that jury,
What does that mean? That they were all white? the demographic makeup of the jury. Yeah, Reuben Carter didn't. It didn't work for him either.
then they've affirmatively waived that objection. They have to do it once again. They cannot accept the jury like Mr. Adelson did twice to his jury and to the alternate jurors.
But isn't really, change of venue is not the same as failure to renew specific challenges to specific jurors. It is a much broader, as Mr. Ufferman was talking about. It has to do with what was known by the community. It's whether the community is one that cannot hear the case. It's not necessarily about individual jurors. So why should we apply this rule that I understand what Armstrong says, but I've also read Joyner, and I know that that's
Joyner, Armstrong, and Blacksmith. Kosher Style says, I think the coffee notification should be Sigfredo saying they defecated all over our reputation. I think it was character, but yeah. They defecated over our character. And it was Katie saying it. I mean, yeah. Maybe Katie just has the natural draw of a voice for notifications. They defecated all over our character.
where the Supreme Court first made this rule very, very clear, and they made it in the context of challenges to particular jurors. Why should we apply it? Forget what Armstrong says. Why should we apply it?
You should apply it because it is about individual jurors. Because Mr. Adelson, he's entitled to an impartial jury. He's not entitled to an
Goddamn mute button. Sorry. David Anderson Cook, how are you going to send it? Maybe send it on Discord. Everybody join Discord. In fact, don't. Maybe don't. Maybe don't join Discord. Maybe Discord should change. Again. But for the better this time. You know, with proper management. And, no. Join Discord if you want, but it might be changing soon, or renewing, or something. I don't know. Maybe. We'll see. But you, David, can send me the link on Discord, and I'll put it on the coffee thing, and we'll all test it together, and then we'll put it to a poll.
Impartial community or city or world. There are people out there who are going to prejudge Mr. Adelson's case. There's people out there that will prejudge every case. In every jury selection, there will be jurors on the panel that will.
There's people out there that will prejudge every case. God, don't they sound like fun people to spend an afternoon with? Fucking guilty. Oh, too much. Yeah, but he's right. I mean, it's probably the norm in a lot of areas or age ranges, or just demographics. In some demographics, that's probably the norm. They just prejudge every case. God, it must be great to know everything without needing any information or facts. Yeah. Met a couple of those people along the way, as a matter of fact.
Say that they believe the defendant's guilty just because he's sitting in the defendant's seat. That happened in Mr. Adelson's case. It'll happen in.
Okay. I mean, he's talking about an extreme version of prejudice right now, but I think there is something to it, and it's a statistical thing, okay? And it does actually make some sense, because prosecutors, believe it or not, are not in the general habit of going around and getting the people that they don't think did a crime. It's a business. And if a prosecutor, say if Georgia Kappelman brought 100 cases to trial, right, and 30 of them turned out to be not guilty verdicts that were irrefutably upheld by some, evidence to be shown later. It would be. I'm saying too much, aren't I? How do you stop yourself doing that once you're in a habit? Gotta be mindful. Gotta be mindful, right? Just don't do it. Don't do it, Metrix. What was I saying? If she had a record of 30% failure, that would be a huge indicator that she was shit at her job, right? And she'd be out. She wouldn't be taking that nice prosecutor's salary home. No. All the benefits gone, right? There's a vested interest that they have, and the court has in general, the prosecutor, the court, in getting it right. It restores faith in the community. It blah 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 blah. Now, for that reason, and for good cause, it's fairly accurate to side with the prosecution. Generally speaking, I know that they're not always right, and I'm certainly not saying that, and I would never say that, but it's not really accurate to come in to be a sitting juror on a trial and say, well, it's 50-50. I'm totally neutral 50-50, because that statistic does not match with the track record of the courts and the prosecutors, because if it did, can you imagine all the money and the what do you call it? The society has the laws, right? And we all abide by them, or are supposed to. At least we accept that we operate in a system where if you don't, there are consequences. Yeah? We're in that system. Now, if that system only got it right 50% of the time, it would be overthrown. You wouldn't be putting up with that, would you? You wouldn't be, hey, look, we've got a chief prosecutor. Half the people she sends to prison forever are guilty, and the other half are not guilty at all. I mean, that would not be a system that you could support or live under. Is it? Right? So there shouldn't be an expectation for a jury member to come in and say, well, I'm completely middle of the road neutral. Now, there are other factors that you can have in place. The state has the burden. The defense don't have to say anything. You can't judge them not for testifying. And I think that people always judge a defendant for not testifying. They're told not to, but it's only this good faith thing that has control over that. All you can do is tell them. And even if in their conscious minds they are absolutely truthful, making an effort not to allow the fact that a defendant didn't testify, not to allow that to be taken into account. What about the subconscious? What about the unconscious? There's zero fucking control over those things. Right? I think it's done. I think the jury system, as cool as it is done. I think we're I don't think it's got long to still be a thing. It's seeming more and more archaic by the day, don't you think? And I'm not pushing for it to be reformed or removed. Like that would make a difference anyway. But it just seems all this stuff of, well, we can tell the jurors, and then good faith, right? I mean, crazy.
In every case that's tried this week at the Leon County Courthouse. It has to do with the actual jurors. One of the things that Mr. Adelson brings up in his reply brief is structural error, and I'm going to explain why this isn't structural error, although Mr. Adelson has waived that because he didn't bring it up in his initial brief. But let's look at the 12 actual jurors that served on Mr. Adelson's jury. Adelson accepted all 12 jurors during the pre-screening phase. All 12 said that they would be fair and impartial. Mr. Adelson gives us no reason to believe them. As Judge Thomas pointed out, there's not a clear record here of why we shouldn't believe them. And Judge Rowe pointed out, because affidavits weren't filed in this case, we don't know what the pretrial publicity is. This isn't like Shepard v. Maxwell. This isn't like Irvin v. Dodd, where, Mad Dog Irvin was in the press, as serial killer, in the press all the time. It's not like those cases. We don't know because Mr. Adelson didn't file a legally sufficient motion.
But he did show that of the 54 prospective jurors who had a considerable amount of media exposure, that 53 of them found that Mr. Adelson was guilty and said that they couldn't be impartial. Now, there's much of jurors might be lying about whether they had the exposure. Is it also possible that jurors were lying that they couldn't be impartial and absolutely thought he was guilty to get out of jury service? I mean, I think there's a lot of speculation going on here that we really can't get to.
Well, that's where I'd point to Singer, a case that Mr. Adelson relies upon. And in that case, and this is a 1959 Florida Supreme Court case, they said that the Florida Supreme Court said they had some doubt as to the impartiality of a fairly large number of the veneer men, which might be indicative of the inhabitants generally of the community. But we cannot determine error on doubt. That's the Florida Supreme Court in Singer.
So would it have been different, for instance, if Mr. Adelson had brought forward evidence that there were 100 broadcasts on the Preston Scott Show, that there were 200 pieces by WCTV, 300 articles in the Democrat, 50, podcasts and court TV programs, and that all of the speakers in those programs, or some high percentage of them, pointed to guilt for Mr. Adelson? Would that be different?
It might be different. All we have is secondhand knowledge of the jurors that were there. That's all we have. It might be different. We have, I think, the court TV host is the only one that we know expressed a negative opinion.
And even the jurors who were interviewed about their exposure to the media sources I just listed, some of them found that those sources were credible, and some of them found that they weren't credible. They called into doubt whether the person who was on one of the news programs was partial or not, right?
Correct, Your Honor. And as to Mr. Adelson's numbers, I disagree. I noted he quotes 29 jurors in his initial brief. I noted 22 that said they couldn't be fair and impartial. But even saying it's 40%, which I believe is what he's arguing today, that's a far cry from Irvin, where it was 2/3 of the jurors had extreme bias against Mr. Irvin. I mean, he was a serial killer that in the press, I believe, several states had, sheriffs had said that they were going to make sure that he died, was executed. One of the cases, Murphy, and I do agree with Mr. Adelson, there are some similarities between issue 1 and 2. And moving on to issue 2, we have to give jurors credit. Just because this young man said that Mr. Adelson was guilty, and another man may have forgotten what he posted on Facebook about Mr. Garcia, that doesn't mean that the entire jury pool was tainted. As Judge Thomas pointed out, the defense counsel was given an opportunity to go.
Good point, right? Good point, because the Charlie Adelson attorney is just pointing to the notion that the jury was tainted without showing the results. He's only pointing to what he says is the cause of the tainting of the jury, not showing us how that cause actually did taint, right? Which is my golly good gosh, just how could you come into a court without that argument? Hey, there was a juror that had an opinion and he was removed, but he said the opinion to others, so new trial. It's our only remedy, Judge, panel.
Go back and review video of the courtroom or the jury assembly room wherever this happened. They were moved from the jury assembly room to courtroom 3G, and the defense declined. So we don't know. There's no indication that
Yeah, well, that would have taken ages and been really boring, and we weren't going to get paid. Of course, they declined, right?
This young man stood up on a chair and yelled this out at the jury pool in general, or whispered it to someone, we don't know. As far as the gentleman with the Facebook page, we don't know exactly what he posted about Mr. Adelson, other than he said something about surprise, surprise. And the defense counsel didn't establish a record. And again, going back to Singer, we're not going to reverse this case based on doubt. This isn't a case, because this is not a structural error, and neither the U.S. Supreme Court nor the Florida Supreme Court has ever held that a failure to change a venue or denial of a change of venue motion or prejudice within the community or biased amongst...
Hello, California Avocado. Yes, the video's on 0.75 speed. Maybe we don't need that anymore. It's just that the first lawyer was pretty fast speaking and talking about some complicated shit, so we slowed it right down. But if that's annoying you, Avocado, then we can just fix that right now. Ooh, normal. There you go.
Prospective jurors has ever resulted in structural error or per se reversible error.
Didn't the Manning court, though, suggest that a venue error is a structural error?
I don't think so, Your Honor, because they looked into, the majority in that case looked into the individual facts, case by case. When we get to Rawling, there and McCaskill, there the courts, and that came long after Manning, they've developed a test to find out. And this is why, in this case, we had two voir dires. We had the pre-screening process and then the actual voir dire, which is, far more than the average defendant gets. And that's so we can suss out and we can identify prejudice amongst those jurors, because no court has ever held that, bias amongst jurors in the jury pool would result in a structural error, because that doesn't affect the framework. Now, if there was something inherently wrong with the voir dire process, perhaps. Now, no court's held that either. But in this case, there was no problem in the voir dire court. The judge here went above and beyond by having the pre-screening process, then the voir dire, where counsel will get an extra chance to challenge jurors. One of the things in this case is the defense counsel didn't ask for any extra peremptories. He didn't even use all 10 of his peremptories until the very end of the voir dire process, which is a factor in Manning. And it's why we have those factors, is because with structural errors, those are errors that are so, such as a right to an impartial judge. It's not like we can question a judge or the right to a defendant's right to represent themselves. We can't question a defendant about why he wants to do that. Or a public trial. If there's no public trial, we don't know what happened. We can't peer in. We can't look behind the veil and see what that error might have caused. But in this case, it's perfectly clear. Mr. Adelson agreed to 58 jurors. The jurors that served on his jury, only one of them heard another juror talking. 3 of them had no prior exposure to the case, and all of these jurors, Mr. Adelson agreed to.
Well, could you address, the preservation issue aside? Let's go to, can you address Mr. Ufferman's fundamental error argument?
I don't think that he can show fundamental error, because he can't show that in any other venue that Mr. Adelson would receive a fair trial. This case, in modern cases often, a fair trial, a different trial, a different result. Fundamental error requires the defendant to show that a different result, but for the lack of change of venue, that his case would have ended up differently. Well, that's not the case here. There's been no demonstration of that.
So it's not just fundamental error that he didn't get a fair jury. Wouldn't that be fundamental error in and of itself, regardless of what the outcome of the trial was?
Well, if he could show that he didn't get a fair jury, but he certainly did.
Well, that's his claim.
Well, it's his claim, but he hasn't shown any evidence of it. He hasn't shown why this particular jury, these 12 jurors, were so biased that, that the outside influence on these jurors would have changed their verdict. He's made no showing of that whatsoever. He didn't try to poll them. I mean, they polled them after the trial, but he didn't try to question the jurors or anything like that. There was a motion later, but
Hey, we got a fantastic poll right there. Look at that, look at that, look at that. Results for Charlie's appeal. Options: win and get a new trial, fail and appeal again, fail and flip, or fail and accept his fate. Tell us your thoughts in that poll.
there's no evidence in the record that these jurors were influenced. Like I said, 3 of them had never even heard about the case. So there's no evidence in the record whatsoever that his actual jury, because he has a right just to an impartial jury, that they were influenced by the media and the local, the conversations around Tallahassee influenced their verdict. There's nothing in the record.
I think his argument is that the media saturation implicitly biased the jurors, I think, is one argument. Maybe another argument is that they are lying. They were lying when they said that they could be impartial. And he's pointing to the 2 jurors who did, in fact, lie. And then again, he points to the 53 of the 54 jurors who were excused for cause because they had consumed the media and felt that they could not be impartial in this case. So that's the evidence he's pointing to. What do we do with that?
Well, Mr. Adelson is asking this court to presume prejudice there, which is something that this court could only do under a structural error argument, which he's waived, and no court has ever held that it's a structural error. This court should not presume error, and Mr. Adelson has not proven any error. He hasn't proven by not filing a legally sufficient motion with affidavits that show what the media coverage was. We had that in Foster. In Foster, the defendant there filed news clips, articles that were far more negative against Mr. Foster than anything that we heard. All we have is secondhand accounts from other jurors or prospective jurors about what the media, publicity was. But assuming what they said was true, what happened in Foster was far worse, and what happened in Rawling was far more extensive. And this court, there's no reason this court should presume prejudice, and there's no reason this court should find prejudice if Mr. Adelson hasn't proven it, and he has not.
Well, Mr. Adelson argued in the brief, or counsel argued in the brief, again, that the media environment in the Rawling case in 1994 is substantially different than it was when Mr. Adelson's case went to trial. What do we do with that?
I don't think that's necessarily true. We don't know much about Mr. Adelson, the media coverage around Mr. Adelson, but in this day and age, no media is really local. And in this case, there was over the My Dead Body podcast, there was national news. People were following this all over the country and all over the world. The environment hasn't,
especially in Portugal,
really changed. Really, the important thing is local sentiment. If it's something that shocked the community, this is as bad as Dan Markel's murder was. 30 people on the jury, prospective jurors, had never heard of the case. In a town like Tallahassee, where people are coming and going quite a bit, it's even.
I believe that. It's so easy to think when you're obsessed that everybody else knows about the Dan Markel case. It's just not true. Other things happen in Tallahassee, believe it or not. Believe it or not.
Less than, in Gainesville, sort of the same situation with Rawling, but in Foster, that murder there with the extremely negative publicity didn't warrant a change of venue. And Foster was after Rawlings. So I don't know that, I understand Mr. Adelson's arguments at times have changed, but I don't think people have. It's the, when we do go to pick a jury, we ask jurors, in that community, can they be fair? What have they heard? Can they set these things aside? Because after all, that is a standard in McCaskill, not whether they've been exposed, but whether they can set aside that exposure.
Does it, as long as we're talking about distinguishing the Rawlings case, does it matter that we have a notorious murder and we have a lot of media from it? In the Rawlings case, we had a literal serial killer.
Okay, well, we've just started a poll, but we're going to do a poll on David's new. Let's just play it anyway. So it sounds like.
Wow, what a nice donation for True Crime Metrix on buymeacoffee.com. Thanks for watching, and thanks for the support.
Yeah, that's pretty good. That's pretty good. I don't know. My thoughts are, should it be, spoken word, or should it just be a sound? Because I think a problem that we ran into sometimes, certainly when we did the Harvey Adelson coffee, buymeacoffee.com/True Crime Metrix alerts, sometimes, it happens at a random time when a video is playing or when I'm speaking. So should it be, this is a question for everybody, should the notification have words in it, or just be a really good sound, What are people's thoughts? I don't know. Does it matter? Thank you, David, for sending that. It's very much appreciated. Let's hear it again.
Wow, what a nice donation for True Crime Metrix on buymeacoffee.com. Thanks for watching, and thanks for the support.
Yeah, I like it. But I think what we need to do is test it in a real life scenario. So how do I download this? Or maybe, David, if you could just send me the, an MP3, or that'd be good.
Killer on the loose, killing people. I don't think anybody.
What? Go back for context. On the loose, killing people. What? Are we talking about the Adelson family? Because that's exactly how they operate.
Can they set these things aside? Because after all, that is a standard in McCaskill, not whether they've been exposed, but whether they can set aside that exposure.
Does it, as long as we're talking about distinguishing the Rawlings case, does it matter that we have a notorious murder and we have a lot of media from it? In the Rawlings case, we had a literal serial killer on the loose, killing people. I don't think anybody in Tallahassee believed that somebody was going to pay Garcia and Rivera to come up to Tallahassee and kill them. That was not an irrational belief in Gainesville when there was somebody who literally was brutally killing people day after day for a while. That has nothing to do with the media coverage. That has nothing to do with what was happening in 1994 when he was being tried. But does it have anything to do with the decision of whether to change venue when you have something well beyond the media in assessing how the community may have felt?
I agree, Your Honor. In Rawling, the Associated Press described him as the next Ted Bundy, basically. And there is that fear and that shock. And I don't want to downplay Professor Markell's death. It was shocking. It was terribly sad. But you're right. It was certainly figured out that this was a murder for hire. And by the time that Mr. Adelson went to trial, this court had already affirmed Garcia's conviction. This was a murder for hire plot. The people in the community were not at danger as they would have been with Rawling or Bundy or even Foster with these Lords of Chaos group. I agree with you, Your Honor, that when that fear stays in a community, that can certainly poison their minds. But in this case, that fear that would have been there in Rawling and Gainesville in the 90s would not apply to Mr. Adelson's case. And like I said, it's not surprising that only 22 jurors said that they could not set this out of their mind. I know
Isn't there a difference here, though? I mean, unlike the Rawling case, there's been, now 12 years of sustained media coverage. There have now been 5 convictions in this case, and at the time of the trial, there had been 3 prior to Mr. Adelson. Doesn't that make a difference?
I think it can work both ways. I think the saturation and the fact that this case has been going on for so long may dull the senses of people. They hear about it, they get disinterested the more they hear. I mean, but I think...
So he's saying that all the podcast media is a good thing because it dulls the senses of the jurors. They're like, I don't want to hear about this. All I hear is, Joel Weldman and his guests.
One of the factors in Rawling is the time of the publicity and the trial itself. In Mr. Adelson's case, the crime was far removed. 9 years, as one of the jurors pointed out, prospective jurors pointed out. But the nature of the coverage matters a lot.
Yeah, I think it must have been pretty cold in the courtroom. Patty's put on a coat. Gone is the T-shirt of love. That coat looks mighty warm. What is that? It's for marine wear, isn't it? A yachter's jacket. A Rab or Helly Hansen. I gotta get me one of those.
Too, and the nature in relation to the time of the trial.
To wear on my yacht.
There's nothing in the record to indicate that there was negative publicity about Mr. Adelson around the time of his trial that would influence the jurors to reach a guilty verdict instead of an innocent, or instead of acquitting him.
And again, that's perhaps where an affidavit may have come in and to help.
Wow, even Stevens with the poll at the moment, 40% apiece on fail and appeal again, or fail and accept his fate. Been sketching out some concepts for the flip theory, which we hope to be discussing with y'all real soon.
Defense in terms of how many media stories there were within the relevant period, the content of those stories. Again, we don't have that in the record. We just have sporadic references in the record where jurors were reporting that they had seen some media at some time.
I'd argue it's why the rule exists. It's why the rule requires
as long as we're talking about
affidavits.
the rule, counsel, I noticed, Armstrong talks about how a change of venue motion is premature until there's been an actual attempt to impanel a jury. I understand what they're getting at, just on its face, but I'm having trouble understanding how that requirement it plays into the requirement that there be a written motion for change of venue. Do you try to, do you attempt to impanel a jury, and then when you can't, you say, hold on, Your Honor, give me a few minutes so I can write out a motion for change of venue because the rule requires it to be in writing. In other words, is the requirement to be in writing unrealistic given the separate requirement that a motion is premature until you attempt to impanel a jury?
No, Your Honor, the rule is not unrealistic because it requires the defendant to make the initial record that he needs to make. And that is, if the defendant files the motion before trial and has the affidavits, which he should, like some of these cases, they went around town doing polls. And in Foster, they got the news coverage and everything before the trial. So it incentivizes a defendant to go out, get the information, poll the community, make the record for their motion, file the motion ahead of time. The court's under advisement that this is an issue, which in this case it was an issue even before jury selection. The court then, the judge in this case, then wisely took the effort to have a pre-screening process and a voir dire. And so the rule is not unrealistic. Now, the Florida Supreme Court says that we have to go ahead and try to pick a jury anyway to see if we can determine whether there is a bias within the community that can't be overcome, but we have to test that. That's one of the reasons I'm arguing it cannot be a structural error, because this is something we can palpably test. And so that's why I believe it's not, the rule makes a lot of sense that it requires a pretrial motion with the affidavits. To conclude, I'll move on to issue 3 briefly. I think in this case, one of the things I want to argue about the evidentiary issues is Mr. Adelson's, when he brought his text messages to the court, he never took the opportunity to untangle them for the trial judge. And the trial judge should not have been required to do that for Mr. Adelson. And that's why I'm arguing it's not just unpreserved, it's an invited error, because when the trial judge asked Mr. Adelson, if you can get some texts for me that are relevant, that would show what you're trying to prove, he just said all of them.
But that is their argument. Their argument is all of them should have been admitted, not 1 or 2 that the judge might find relevant, but all of them. How can you waive that argument simply by refusing to cherry pick ones?
Because the only relevant arguments would have been if there were any relevant. I argue that even these weren't relevant. But the conversations between Meg Benoit and Donna Adelson and Wendy Adelson, he didn't separate those out and offer those to the court and say, these are the relevant text messages, and this is why they're relevant. He should have done that. The judge was under no obligation to untangle those for Mr. Adelson.
And I think there was concern about the content of the message. I think you characterized the messages in your brief as racist, misogynist, and sexist. And I can imagine that had those been admitted, Mr. Ufferman might be right up here arguing unfair prejudice against his client because of this bad character evidence.
Correct, Your Honor. The judge has to act as the gatekeeper of evidence in every case, and in this case, we may have very well had an ineffective assistance of counsel in the face of the record argument had the judge not asked pointed these things out to Mr. Adelson and asked him.
Is it really the judge's job to protect the defendant from himself, though? I mean, if counsel believed that the strategy included,
I think that was a what do you call it? Rhetorical. I think that was a rhetorical question. Is it really the judge's job to protect the defendant from himself?
Admitting these text messages that might otherwise be viewed as negative to them, isn't that really a strategic call on counsel?
It'd be a bit like, if Charlie Adelson was looking at the lunch menu options and about to make a bad choice, Judge Everett would be right there, over his shoulder saying, no. Order the Cuban sandwich. I've just had 3, and they're really good. Protecting him from himself. He was just about to order a bowl of Skyline chili. Ugh. I don't know why anybody would put photographs on their website with food that looked like that. Look at it. Skyline Chili. Horrible stuff. I mean, it's almost like a joke. It's like art, conceptual art. Where's that? We need another browser. Not that. That is what you were going to order, Charlie. Why? Why would anyone want that? Look at it. Heavy on the cheese, yeah? I mean, Cuban sandwich. Judge Everett has got it covered. 3 Cuban sandwiches. He calls it his usual. Can I get the usual? Is it 3 today? Give me 5.
Spark?
If it's a strategic call that no reasonable attorney would take, I think a judge does have to step in. A judge will have to step in even under a 403 analysis. If something's more prejudicial than probative, in this case, those texts were certainly more prejudicial than probative. Yes, a judge should step in.
Even if it's prejudicial to the offering party? Just
yes,
now,
sir.
I'm not going to allow you. I think that would harm yourself if you admitted that, so I'm not going to allow that evidence in. I don't think I've ever seen that.
I think in the interest of not vitiating the entire trial, a trial judge should do that, and because otherwise, he's letting the defendant walk himself into a mistrial, and a judge should not allow that to happen or be forced to allow that to happen. Based on those arguments, Your Honors, I would ask this court to affirm Mr. Adelson's conviction for his part in the murder of Daniel Markell.
May it please the court. I'll begin by briefly addressing Claim 3. Here's why it was so prejudicial to my client to not get in the other text messages that the state was pointing to and suggesting that they had to have been about nefarious things as opposed to routine things. The text messages that have been proffered, they clearly are routine things. This is what the prosecutor argued in closing, page 2082. Quote, but as the defense points out, these folks had independent relationships with each other that could explain those communication patterns. So without knowing the content, how could we know if they're really talking about murder or if these call flurries around key events are just coincidence? A conspiracy can be shaped like blah, 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 and she goes on. Without knowing the content, the state objected to the jury being able to see all of the content. And now they seize upon that in closing argument?
I'll ask you the same question I asked the state. I mean, if these messages, which were labeled as racist, misogynist, and sexist, had been entered against Mr. Adelson.
And what else? Racist, misogynist, sexist, homophobic. What else? What other great traits? Immature. Not funny.
Wouldn't you be arguing here that the jury was prejudiced against him in terms of this bad character evidence?
Absolutely not. Number one, that would be the actual definition of invited error. Number two, my client would be, I'm sure it's not great, but he can take the label of being racist, misogynist, whatever else. He doesn't want to take the label of being murderer. And these texts would have helped him show that what the state was arguing is not true, so much so that the state seized upon it. He doesn't need protection from himself, as Judge Winokur's already indicated. He has a right to put on evidence that he thinks is relevant. Mateo says any evidence that could be in any way, even in a slight way, relevant to the theory of defense, a judge errs in not allowing it in. The purpose of putting these texts in is not, as the trial court was saying, do they go to motive or they go to any element of the crime? No, they go to showing that these are routine communications, not what the state is asserting. And he was prevented from putting that in, and the state seized upon it in closing.
Was this, if there was error, is it not harmless? He was allowed to testify about these texts on the stand?
Wow, my client was out on an island in this case. There's no question that it was, one other witness was presented. My client's testimony. Is there anything to back up my client's credibility? This would have been something that the jury could have looked at and said, wow, Mr. Adelson saying that he didn't do this, he didn't hire these people, he's the one actually being extorted. But there's nothing that supports that other than his testimony. This would have been, wow, look at the text messages. See them for yourselves, ladies and gentlemen.
How was your client on an island? I mean, certainly he could have brought forward the mechanic he was having the conversation.
He wishes he was on a fucking a goddamn golly good gosh island, doesn't he? That'd be nice. Or a boat. Or take a boat to the island. Oh. I don't think he should be using this kind of language when he's discussing strategy with his client. You're on an island. And Charlie's brain goes instantly to what? What does he say? All you gotta worry about is who is massaging my feet on what beach today. Oh. Should that be merch? Should that be like ironic merch? Should that go on a coffee cup? Should that go on a buy me a coffee cup? .com/True Crime Metrix. Yeah, was it? Who is massaging my feet on what beach today? Maybe it should.
With and all of the other people to testify about the kind of communications they had with your client.
You all know very well that I think defense counsel was ineffective and had a conflict of interest.
Okay, but you told us that they did great lawyering. You're the one with the conflict. You're conflicted in your assertions. Here, now.
I'll raise that at another date should I need to.
But it's clear that
Look at Ted Danson in the background. He found that really funny. Look. Ted Danson is just normal, serious face right now. Watch him crack up.
on an island. I mean, certainly he could have brought forward the mechanic he was having the conversations with and all of the other people to testify about the kind of communications they had with.
Yeah. You see, MC Hamster, or maybe M Chamster, has said Charlie's brain would go, listen, the thing about an island is, you know what's great on an island? You remember that soft shell crab place on the shore? Yeah, why don't you go there for lunch, and then you could leave your bags in the hotel and get a shiatsu before you get the boat home. He'd have been. He thinks he's like a travel agent, doesn't he? Telling you about the activities and what you can do. And no. There's this great frozen yogurt place. Why don't you eat at the soft shell crab joint, and then don't get a dessert there. Take a walk up. It's about half a mile. Stroll after dinner, frozen yogurt, and then you'll be on the beach for evening sunset, as opposed to morning sunset.
With your client.
You all know very well that I think defense counsel was ineffective and had a conflict of interest. I'll raise that at another date should I need to.
Look at Ted Danson. He's fucking. Yeah, he's golly good gosh. High. Look at him.
The kind of communications they had with your client.
You all know very well that I think defense counsel was ineffective and had a conflict of interest. I'll raise that at another date should I need to.
But it's clear that your client was not on an island. That there could have.
I'll raise that at another date should I need to. Well, here's your opportunity. I thought this is your appeal. You see, there's one thing that, believe it or not, Charlie Adelson still has in his favor over your regular defendant, and that is money, right? Appeals are not cheap. And, you know, we saw in the case of, you know, that Moosehead murder up on, where was it? Nova Scotia or Newfoundland, one of those places, and he just kept coming back with the appeals, appeal, fail, new appeal, another one. Okay, when you've got bottomless cash, you can afford to do that, and if you can afford to do that, you can afford to see what sticks, right? And it worked for him. What was his name? Totally blanking. The Moosehead murder, you know. Don't say you know. Got to stop saying that. Got to stop saying that. It happens automatically and too often. It's... is it Derek? No. Olson. Someone... I've got to find out. Moosehead murder. Richard Oland, not Olson. Oland. Richard Oland. No, that's the dad. Dennis. We knew it was Dennis. Of course it's Dennis. Dennis Oland. Yeah. Well, he got out on appeals, on repeated appeals. Why? Because he had money.
Been evidence presented that would have corroborated what was in the text messages.
I agree, and the judge prevented it. That's the whole reason for Claim 3.
Counsel, I want to go back to something that we talked about at your initial argument about what needs to be shown to strike the entire panel. Now, I did look and I saw that this wasn't cited in any of the briefs, but I'm going to say it anyway. It's Morris, Florida Supreme Court from 2017, and the quote is, for the state.
So what is needed to strike the entire panel of jurors? So that would have been 50 people. I think it said 51 until 102, which is a strange way to do it. I mean, that's 50... 2 people, right? Isn't it? I think so.
Statement of one veneer member to taint the panel. The veneer member must mention facts that would not otherwise be presented to the jury. So,
must mention facts that would not otherwise be presented to the jury. So, what wasn't presented to the jury in Charlie Adelson's case that was not admissible? Oh, I can't remember off the top of my head. But if someone had gone, hey, you know, that thing that the judge has ruled, that makes total sense, doesn't it? So if a prospective jury member says to another, hey, they never found the gun, but it's been ruled on that can't come in, that would be something where they'd have to all be stricken. That makes perfect sense. And that's why we have the laws there, isn't it? So that we can refer to them.
So is that the correct standard to be used in striking an entire panel?
I think that's one aspect of it, and I acknowledge that's not met in this case. Clearly, the facts that were discussed did come out during the trial. I think the bigger issue is the expression of guilt. So I think the case that's closest on point is Brower, cited by the state.
It's an opinion. It's just an opinion. I think he's guilty.
And Brower, the comment that was being made by a particular juror was they should just hang him. And this is what the 4th DCA went on to say. This is on page...
They should just hang him. Imagine if we got to see that. Like the Saddam Hussein hanging. Just recreate that. Can we do that with AI? Recreate that scene, but with Charlie Adelson. That'll be fun.
10
I mean, they can do so much now, can't they? They can basically make anything with AI. So why don't we make that? How do we do that?
27 of the opinion. The offending members of the veneer were facing a 3-week murder trial and were enduring a tedious and lengthy jury selection process. They certainly used poor taste and worse judgment. However, there is nothing in the record to indicate that the offensive remarks were offered or taken seriously. The 4th DCA is finding that the comment, he should just hang himself, was literally a joke, not an expression of the defendant's guilt. That's not at all what we have in this case. I see them into over my rebuttal time. I would ask this court to reverse, and I would end with this. If there was ever a case for a change of venue, these facts are that case.
Counsel, my colleague has a question,
Oh, of
so
course.
I'm going to extend your time for her to ask it and you to answer it.
Thank you.
Inappropriate.
I do like this guy though. He's funny. He's just, you know, in his carriage. He's all right. I'm not offended by him, you know. Don't say that, Metrix. Slap my wrist. Do it again.
Your last sentence said on the facts of this case, and that's what bothers me, and I would like a response from you. The fundamental error argument. In this case, on this record, we're arguing speculation. If you're arguing fundamental error, and you're asserting speculation of prejudice by the jury, in practical application, you're lowering a fundamental error standard below even abuse of discretion to me. So, you know, on this record, your argument on fundamental error to me, I guess, help me understand what more than speculation is backing up your fundamental error argument.
Yes, Your Honor. And it would be, and I know they've been mentioned, but I will go and I have them written down right here. 40% of the jurors had formed, of the 130, belief that my client was guilty. Only one had not, or thought that my client was innocent. 3 prior cases, as has been discussed, and one of those cases was 2 trials, one of which occurred a year before. 10 years, almost a decade, this case has been going on in this, as the judge said, small community. 2 jurors lied. So it's not just speculation. If I was suggesting that, you know, based on this, we can suspect that some jurors are not willing to tell the truth and really tell the court that they've already formed an opinion. We know 2 jurors lied. One of those, well, both of them lied and specifically had an opinion about the case. And ultimately, the jurors directly violated the court's order and talked about the case even though the court specifically said don't do it. When you consider all of those factors in their totality, we establish fundamental error in this case. Thank you.
Thank you, counsel. Thank you both. This court is adjourned.
All rise.
Do you think they enjoy wearing those black robes? I always wonder what they're wearing underneath. Nothing. Judge Everett wears nothing underneath. Oh. No, of course he does. Something with a lot of pockets. His hands are always disappearing. You know, like the Secret Service guys that have a fake arm so that their real arm is like constantly on their weapon. Judge Everett has the same thing, but so that he can take a cookie out of his breast pocket without anybody seeing. Oh. Where's those Secret Service guys with the fake arm? Secret Service fake arm. You know, this guy. Don't say you know. What are we going to say instead? I'm going to find something. It's a bad habit. It's a bad habit. Hard to break too. Once it gets you, it's worse than nicotine. What am I doing? Oh, this thing. Just want to put this image on the icons. Now just imagine what Judge Everett could do with these tactics. Oh, hang on. This is saying that it's real. It's a real arm. Now we have to show the video and do a poll. Secret Service guy, fake arm. Inside Edition. Yeah, I think I heard of those guys. Everybody subscribe. Inside Edition. Do we need that anymore? I don't think so. We're done with the appeal.
Look at this video that's sweeping the internet. It's the inauguration parade held in Washington last week. Check out the Secret Service agent. His hand isn't moving. To some observers, it seems to be a prosthetic hand, known as a tactical fake arm. Is it
Judge Everett's probably watching our show, this live stream right now, going, okay. Give me a phone number for Prosthetics R Us. Comes back tomorrow with a car load full of fake rubber arms.
possible that his real hand is holding a gun tucked inside his coat? That's what some are saying. However, some people are debunking the theory, citing moments like this, when the agent appears to move his hands and later closes the limousine door. His fingers are clearly moving.
Okay. So, or maybe he switched it so as not to, let the Russians know the secrets. Or something to that effect. So what we wanted to do now, as it's Donna Adelson's 76th birthday, is take a look at some calls, post-conviction calls of Charlie Adelson calling his mother Donna, right? And others, but mostly Donna. Always, mostly Donna. Local.
Hello, this is a prepaid collect call from an incarcerated individual at the Leon County Jail. This call is not private. It will be recorded and may be monitored.
Thank you for using Securus. You may start the conversation now.
Hey.
Hey, Charlie. Charlie.
How are you guys?
Okay. We're still talking to you, so that's good. We're still talking.
It's such a show.
I'm going to say anything. Don't even say anything. It is what it is.
There's no reason for Donna to be behaving like that on the phone. It's a show. Of course, she will be upset and frantic and panicked and, ruined. Worried about her own ass as well. But it's done so that other people will. It's not genuine, is it? She's doing that as a method of communication, a manipulative communication.
They had their minds made up, walk out in 3 hours.
No, trust me, it is.
I knew what jurors selection.
Yeah. And with you, Donna, they didn't even take that long.
I knew what I had when I was up here. I knew what I was dealing with.
Yeah. I knew. And I love this thing of Charlie. Charlie, even in the face of his own conviction, still does not squander the opportunity to tell everybody that he was right. I knew I would get convicted. See? That's how good I am, because I knew.
Look,
it is what it is.
Have you spoken to Dan since he left?
No, I called you.
Yeah, there's something that he told us. You need to talk.
No, I have not spoken to him. He said he was going to go to lunch. A long lunch.
You need to ask him what.
Judge Everett said something about Cuban sandwiches, and his eyes lit up like Christmas trees.
Ask him what you tell my parents.
Yeah, no. I'm going to talk to him, but I'll call you in a little bit to take his minute, relax. Not getting upset, not going to change anything. So I'm going to get you checked.
All right, call Dan, ask him to tell you what he told us, okay?
Listen, I'm fine. Just take something to relax, okay?
All right, we're going to be okay, Charlie. Just
take something to relax, Mom. Take a whole bottle, Mom. Tell Dad to take a pill. Take a pill, Mom. It's another good merch, isn't it? Take a pill, Mom. Make Dad take a pill.
please give Dan a call and call us back later, okay?
Yeah. Tell Mom to take something and relax.
I will.
I know what I was dealing with. She didn't take something to go crazy and get upset.
Okay. I love you. We talk a little bit later. Okay?
I got full power on my phone, but I'll call you guys in a little bit tonight. And that's,
All right, just call Dan first, okay?
I'm going to call her in a little bit, but I'm calling Dan first, okay?
Okay.
Love you guys.
Love you, Charlie.
The caller has hung up.
Love you, Charlie. It's going to be okay, Charlie. We're looking at options. For us.
Hey, guys.
Oh, Charlie.
So
you spoke to Dan?
Been there for a while. Been there for a long time. He was okay trying to go eat to get out of the room. He stayed on it for a long time, wasn't he? He said he was going to call you guys when I got off the phone with him. I was going to call you in a little bit.
Yeah, he did. Were you able to get through to Bree?
I took the break. Roland has fallen asleep in her lap.
Okay.
She's when I was in a Roland, I'm like, just don't say anything to him yet. There's no reason to.
No.
Yeah, I can't handle that. That's honestly the only thing.
No, I know.
Yeah, don't tell Roman. Don't tell Roman a thing. There's no reason to tell him. Because if we tell him that Dad has gone to prison forever, then we're going to have to explain to him what a prison is and what a criminal is and why he shouldn't be. It's just a whole thing, so don't tell him. Get him a guitar. That's what we should do. And some music lessons. I want him to be trained by Joe Bonamassa, call Joe and tell him to give lessons to Roman.
You don't have to do anything now. No. Honestly, the only thing I really wanted to do is a good dad in my life. Is to be a dad, have a son.
All I wanted to be is a good dad. Well, you weren't going to be one anyway, so, what if we really lost here? All I wanted to be was a good dad. A good dad on a boat, and a jet ski, and a go-kart. That's what I wanted to do. And with a lot of different women that I lie to repeatedly and don't treat as equal human beings. That's all I wanted to do, Mom. A good dad on a boat and with a jet ski and a go-kart that has multiple women that I lie to daily and don't treat like equal human beings. That's all I wanted. And money, a lot of it, money.
I know. Believe me, I know. I just wanted to be a dad. I mean, when I was with Brie, I dated her for 6 weeks. I found out she was pregnant 6 weeks after we'd broken up. And I was like, no, I want to keep it. I want to be a dad. I know you did.
Yeah, I know, Charlie.
Yeah, so I ordered her to reproduce. Yeah, I found out about the baby 6 weeks. It'd be funny if it wasn't his, huh? Oh. Yeah. He's blonde, Charlie. I know he's not. Yeah. I found out she was pregnant 6 weeks after we'd broken up, so I ordered her to not abort.
Okay.
Take a breath, Charlie.
Take a deep breath, Charlie, please.
Mm-hmm. Honestly, I'm like, I don't know if I'm in a state of shock. Yeah, you're in shock. We're all in shock.
Yeah.
We're all in shock. I had a feeling, though, so it's not like, listen, I've been up in Tallahassee for a year and a half. I mean, I got a taste for how big this case was. I had no idea. There was no way in hell I was ever going to get a fair trial up here. No, but that's way in hell. No. Listen, even with the jury consultants, they ended up using X's on people that were like fucking horrible. Like not even like selection. It was just like get the people off that you like. I mean, honestly, I sat there and like the same people that I said let's X off our jury. To be honest with you, were the same people the jury consultants were like, yeah, you can't have these people on your jury. So it wasn't even like picking good people. It was about just keeping the fucking horrible ones off that we couldn't have come on. There was no like. Every time I said, oh, this one, I had the same numbers down that we had to get rid of.
Yeah. And the way that Josh Dubin told it to me was like, if we paid him $1 million, then he'd make sure that he'd have 12 rich white dentists that also have a similar lifestyle to me. And maybe a few people that I know and can pay under the table. That's what I thought we'd get for $1 million, but it just wasn't that, Mom.
Yeah, I don't know people that had to get rid of it. There was no, I know.
There was no one to bribe. Is that what they were just saying? Because Charlie says, there was no, and Donna says, I know. Just sounds like they're saying there was no one to bribe. There was no way to get the money to them undetected.
Just keep up the horrible ones off that we couldn't have come on. There was no like. Every time I said, oh, this one, I had the same numbers down that we had to get rid of. Yeah, I don't know people that they had to get rid of. There was no. I know. Listen, these people didn't deliberate. We know what happened. They were decided before. They went back, filled out their papers, and came out. That's not a deliberation.
These people.
They looked at a couple things. I got on it at probably 8 for an hour, and then talked about some stuff. Went through the paperwork.
They probably ate for an hour, then thought, hey, is anyone in the mood for like a nice espresso coffee and a gelato? Because there's this great gelato place around the corner. And then they went there for another hour, came back and filled out the pet forms.
Because they went all the way to like, I guess 1:30 with the opening stuff. And they probably took lunch till 2:30.
Yeah. It is deliberate. It did nothing. It did absolutely nothing. The vigilante.
When they came in and I saw when they came in this morning and nobody looked at me, I knew they'd already made up their mind.
Yeah.
Sometimes I wish I went with my gut instinct for life.
Dan did a great job. You spoke well. They listened to nothing. Absolutely nothing.
They cut and pasted emails. They cut and pasted lines from text messages and gave us their own meaning. You know, like, oh, kissy face. Oh, like.
I saw what they did. Oh, it's a mistake. Nothing.
It was like, I don't know. It was like they dressed it up into something it wasn't. They just I don't talk about it. I'm in shock. I'm partly in shock.
I don't want to talk about it. They dressed it up as something it wasn't. Oh, I don't want to talk about it. Well, what do you want to talk about? Seems like today we really only got this to talk about, right?
Partly not surprised. Partly just certain things that I don't want to go into, but I just wish I went with my gut instinct. My gut instinct was I wish I would have gone with my gut more in life. What it's about, right? So you guys take care of yourself. I mean, not saying I need to.
I think we need a gut counter. How many times does Charlie's gut tell him something? I should have gone with my gut. My gut told me.
You guys stick out there. One more thing on my head.
Yeah, no.
Yes, I don't have much. You know, I don't really have much in life anymore. So it was something happened to you guys.
Well, you know. Oh, God, again. Stop saying that. You've got more than Dan Markel. Huh?
We'll be fine.
We'll stay tough for you, Charlie. We'll stay tough.
Can anyone understand this? How Donna, what did she say at her sentencing? Or at some other point? That Dan Markel, had he have watched her trial of his own murder, would have been appalled at the miscarriage of justice. I mean, that's bad taste, isn't it? My murder victim would have been appalled at my trial and the corrupt judge.
I don't even know what it's going to be like, but I did ask Dan, if they put me in, if they maybe get me in some protective, it's called protective management, where people are like, that I guess have high profile cases, or people that are like police officers, when they go into custody, they put them in certain areas.
Sounds like there's going to be even more restrictions on Charlie in protective management than just your average Gen Pop prisoner, right? Even less time out the cell. Even less time seeing other human beings. More restrictions in protective management.
Put them in general population.
heard this camps don't like that.
Yeah. Sorry. I guess you're not gonna. I guess you wouldn't do well in general population, Charlie. I mean, imagine if they put him with Sigfredo. Imagine if the system was so fucked up messed up, that they said, yeah, okay, well, let's house these guys, together in the same cell.
They're going to work on that. They're going to work on the appeal.
Right.
I mean, listen, it's such a high profile. It's like you have to get an appellate lawyer. It's such a high profile case that, I mean, listen, everyone's saying all the right things. Listen, I had a blessing. I really did. There was about 45 out there. And,
let's see what develops.
Yeah. They should put Sigfredo and Charlie in the same cell and then let them FaceTime on their shared tablet with Katie. That'd be hilarious. And film the whole thing. I mean, that'd be the best reality TV that you could possibly come up with.
Well, the judge gave these people plenty of warnings. I'm sure they followed their little instructions.
I'm sure they did. Yeah.
So listen, these are people who took a Appleman. These are all people from Tallahassee. There's no way there's no way Mr. Under a rock. There's no way you don't know about this case. This is the biggest. This is the biggest case they've had up here since the 80s. This is.
Charlie, they weren't listening.
Since Bundy, they're calling me Dentist Bundy, Mom.
Weren't listening to anything, because if they had a brain and they were listening, it was very clear.
If they had a brain between them, the jurors, if they had a brain, it was clear. Not guilty. Everybody's been saying it. All the people that Dan Rashbaum paid to say, hey, listen, keep sending them messages saying how well it's going. Act like you know what you're talking about. And then maybe I'll be able to do the appeal as well, because I got to get some more billable hours.
They don't listen. They just go. They just do. They don't listen.
And they're hammered with someone like Georgia Capitol.
They don't think. They just go. They just do. They just do without thinking. They just act. They're apes. These apes on your jury.
Well, they real simple for them.
She didn't even. She had no evidence. She had nothing.
No. They had emails.
Where was the evidence? We've got to go over Donna Adelson's letter that she read out at her. It was supposed to be a, what do you call it? Allocution. Miss Adelson, you will be able to continue, but I want to point out the complete, utter lack of remorse that you are displaying. I mean, imagine a judge says that to you at sentence. I mean, how impactful, right? He's about to pronounce sentence, and the thought is, if you're really good at showing remorse, right, and the judge believes it to be genuine, then you might be able to get some kind of reduction or the minimum sentence. I mean, I think it's just set, but maybe he could have not given her consecutive to whatever it was. What was it? 30, 60, 90, whatever. So when a judge says the total, utter lack of remorse that you are displaying, it means something, doesn't it?
Look at the emails. Oh, look at the emails.
Yeah, subscribe and the bell. Hit the bell, hit the subscribe, and the thumb, like the video.
Which is...
The email that never mentions anything about danger or violence.
I trust me. I know that it's not how that's not what they use it for. They use it to paint a different picture. To paint a picture. You know, I mean, Jesus Christ, they made a deal about me calling the home line. We've had it since 1979. Like, you only lived there for 3 months in 2000.
That you've had since 1979. And he's saying 79 because I bet Donna Adelson, she's the kind of person that would say that. We've had the same phone number since 1979. Yeah, even when we move house, we pay the phone company to retain the number, which nobody does. I've never done that once. Even with cell phone, don't say you know. It's like a tick. It's like a horrible, horrible tick. You switch providers, you get a new number. I don't know how many cell phone numbers, mobile numbers I've had. Maybe, I don't know, 15, 20?
So you're only there 90 days in 14. They're going to charge.
But Donna, that would be a point of pride, wouldn't it? Why? Because it costs money. It's like, no. We moved house and we paid the phone company to retain the number because we can afford it. So she would always be saying throughout his life, we've had the same phone number since 1979. If it hadn't have been drilled into Charlie's head, he can't remember things. That's why he repeats things. He has nothing original left to say. What? It's been drilled into him. And they pick up each other's vernacular. It's like a trade war. 1960. If it hadn't have been drilled into him, he would have just said, "You've had the same phone number like all my life, or forever, or something more general, right?" But no, he says 1979. Hear it again.
They just do. They don't listen.
Yeah, and they're enamored with someone like Georgia Catwoman, who makes it real simple for them.
She didn't even. She had no evidence. She had nothing.
No.
He's kind of having a backwards dig at Daniel Rashbaum there, I find, because he's got this big thing of like Georgia Kappelman had a PowerPoint slide that made it really simple. Maybe Dan should have, and then Donna's quick on the defense of Dan, right? There's this little thing there, and then she's straight on back on slamming Georgia. Yeah, but she had no evidence. It wouldn't have mattered. It was rigged. Dan was perfect because he brought me a cake and said he liked my shoes. That's how Daniel Rashbaum gets the job, isn't it? Those shoes. My mother has a pair of shoes like that. Will you be my fake mom while I make you sign this retainer?
They had emails. Look at the emails. Oh, look at the emails. Which is...
The email never mentions anything about danger or violence.
I trust me. I know it's not how that's not how they use it before. They use it to paint a different picture. To paint the picture. You know, I mean, Jesus Christ, they made a deal about me calling the home line. We've had it since 1979. Like, he only lived there for 3 months in 2014. So you're only there 90 days in 14. They ran a charge going to 16. Well, yeah, it's because the house was sold in 15, and you're only there 90 days. And there's nothing special about calling my home phone. But they put up a pie chart, and they made it look like there was something very suspicious about calling you at home.
Yeah. It's just a picture. They painted a picture without evidence. That's what they did.
Yeah. They literally.
Hey, check this out, because I've just seen this thumbnail and I need to ask a question. So I'm seeing quite a bit of this kind of stuff at the moment, and I'd say I'm against it, okay? So I don't know who that is, but and this is like an AI program, right? Where somebody has generated a picture of Donna Adeslon screaming to camera, based on uploaded images of her, something like that. And the same thing with Charlie, right? That's not a picture of Charlie, but it's based on a picture of Charlie. It's AI generated, and I don't like it. I like using the real people and trying to do something nice looking. I mean, where's that thumbnail? It's not the best today, but isn't it better than how do we? Yeah, it's no good. It's no good, but it's colorful. You know, it's real. It's all the real people. That's the important thing, right? That's the important thing. You know what I gotta work out? I gotta work out how to get the full scale pictures from the Tallahassee Democrat website, because all the time on Google Images there's a nice full frame 4,000 pixels wide photograph that comes up with the search results, but the only thing that it links to is like a teeny tiny picture, which is like there's the guy from the state there, the lawyer for the state. That was a tiny picture, so he's all fuzzy. But there's got to be a way to get that with a link or something. Anyway, that's for me to know.
They had a theory. I don't know what to talk about anymore.
Yeah, there's no point. There's no point right now.
No, I can't really talk on it. Even though this is a calling on a landline.
Yeah.
Right.
I know.
Right.
All right.
So it's only for the night that they moved me over to E1 because when you get convicted.
I think we should end the poll now. Results for Charlie's appeal: 53% believe that fail and appeal again is the most likely option, which, I mean, his lawyer let the plan out of the plan bag when he said, well, I'll come back with ineffective assistance of counsel. Couldn't we do that all in one day? Just get it done. Just get it done, and, you know, bring everything all at once, and we'll make a special long day just to get it done. Yeah, let's end that poll. That beautiful pole. Look at that pole. So nice.
They notice like this. They
I'm not
like,
say that again. They're moving you?
no, they already did. When I came back to the jail, I had to roll up my stuff and they moved me to E1.
And
But
what is that?
they let me keep my clothes. I'm not in my regular cell anymore.
Yeah. No, I thought that the jury were going to come back, say not guilty, and then I would be released and Dan was going to drive me home in a nice Lexus. Or what does Dan drive? What does Dan drive? I don't know. That Cadillac from Better Call Saul, maybe. All lawyers must have one of those. But instead of driving home in a nice Cadillac, they told me to pack, and then they took me out of the shit room I was in and put me in another smaller room with literal shit on the walls. So, and they took my Apple as well. They didn't let me keep that.
Is it your own cell?
Yeah, it's my own cell, but it's got a hole in the wall and shit on the ceiling. I can't see the glass. It's got a video camera. People fucking screaming.
I know, I hear them.
And I'm just like in my little cell, like a solitary green cell with lights on. I can't see out. Like I said to the officer, put me in here. I'm like, listen, I'm not suicidal. But I guess whenever you're convicted and stuff, they put them in one of these for observation. The chief of the prison can come talk to me tomorrow. They're going to have a therapist come talk to me tomorrow. I'm not suicidal. You can't leave me in here that long. You can anything with yourself. They know they can talk to you in the morning. I'll probably get moved back to my pod and back to myself. They just do this, a precautionary thing.
Yeah. Oh, God.
That's what they sometimes, right?
Not even believable. Unbelievable.
I don't want to say no way to any of the fellow lawyers because this case is so big. It is so publicized. This isn't some guy trying to get an appeal on the case. This was like what had to be sold up here. They had live coverage. They had, they pull out all the stops. It's not something.
I know. I know what they were
not making a mistake. You know what I mean? It's not like, we thought for some minutes he got brought back on appeal, or the judge made a super ruling. They were dotting every I and crossing every T. I love you guys.
I love you, Charlie.
I love you, Charlie. I love you. I love my
Get through
whole heart.
tonight and get
Please.
through tomorrow, and just call us anytime, please, okay?
Yeah, no, listen, take something so you don't end up having a heart attack tonight, okay?
Okay.
Listen, I love you guys a lot, okay?
I love you too.
I love you, Charlie. My whole heart. I love you. Please. I love
Please
you.
understand, just take care of Roman for me and keep an eye out for him.
You know I will.
We will.
I know it.
And that's Wendy. By the way, I wrote Ben like a month ago. He never wrote me back.
I know. I'll find out.
I guess he thought it wasn't urgent, my God. Now that I've noticed it. No, I guess he thought it wasn't urgent. That you wouldn't be going anywhere.
No. How's Wendy doing?
I can't talk to her. I don't know. I don't know.
You don't talk to her?
I did not talk to her. I can't do it. I can't talk to her. Anybody else but you. Good fan.
listen, I love you guys a lot. Okay, everything's gonna be fine. I'm gonna be strong.
I know you will.
And Dan's gonna look out for me. They're gonna try to. I already told them, so don't harass them about it because I've already spoken to them, said it twice, and they said they're definitely gonna look into it and do what they can.
Exactly. I know. I know. Say that again.
Yeah, about the protective, trying to get me into the protective management because of the publicity on the case.
Right.
And look, I don't want you guys. I know you're upset. I just don't want you guys getting sick over this.
We won't. You just be strong, okay, and it will be fine.
Yeah,
you're strong.
I've been dealing with this for how many years now?
Yeah.
You know, it's like.
You're a brick wall, Charlie. You're a bear breaking through a brick wall.
No.
Now you get what I listen. I haven't been myself. Listen, for me, for how many years for how many years I had it was hard to be normal with everything going on. It just had, and I still try to work and it still works and I'm still I don't think nobody ever got what was going on in my head.
No, I know that.
Nobody ever knew. But I always had like I always had a feeling.
No, I know that. I know that.
I remember, honest to God, I remember the last time that we all went to the show in Rome and we were taking video. You don't really want to know what I was thinking in my head.
Mm. We'll take care of Roman, but just hang in there, okay?
Hang in there, Charlie.
I'm good. No, listen. I woke up today in jail, going to bed in jail. Nothing changed for me. Unfortunately, we didn't win. I don't even say it. I'm still in shock. I'm still, honestly,
I know.
I cried a little bit when I got in the cell, but I'm still.
You're strong. You're strong.
It's set in, but it hasn't set in, and
Of course not.
It doesn't feel real, and it's almost like, if it makes any sense, it feels like it's no different than it was yesterday. I'm just in the same cell.
Yeah.
Yeah.
But it's like my worst fucking nightmare, to be honest with you.
Yeah. No, I know. I know, Charlie. I know. It's for all of us. It's for all of us, Charlie. It is for all of us.
I don't know what to say.
I don't know what to say either. We're here, Charlie. We're here. And anything that can be done, we're going to try to do. You know that.
No, I know, but don't. Do me one favor and don't get sick. Listen, tonight, please take something now if you haven't already.
We already did.
We did, Charlie. We did.
Take another one. But listen,
all right.
Down from 1,000, Mom.
I know.
I love you, Charlie. I love you.
We love you more than you do. Hang in there. I don't want to make.
Hey,
hi, Charlie.
How are you guys?
We're okay.
We're all right.
By the way, I only have $15 on my phone.
On your phone?
Yeah, that's it.
Okay, I'll take care of it right now.
Yeah.
Okay.
I called Michael. I talked to him for 20 minutes.
Yeah. No.
I think he had texted you guys.
You did. What about commissary or eye care? What about those things?
I got food for. I'll get the food when I get back into the pot from the guys I gave it to. I'm not that hungry. They had chicken tonight. Chicken that I ate. They gave me 2 packages of tuna fish back. They'll give me my food back. Last night I thought I may be getting out today, so I gave away all my commissaries that I had saved up.
All right.
But the 2 guys I gave it to,
the two guys that gave.
Yeah, I gave my apple and my commissary to another inmate, and he gave me half of it back. Brown half apple came back. Came back. It's the high point of my day, my year.
So they'll give it right back. It's not.
You know, there's good people in here, Mom. Half an apple.
They're not keeping it or anything. But I'm just in this one cell for the night. So they just have me like, yeah, I'm just in the cell for the night. In the morning, the chief of the jail is going to come see me, and they're going to have they have like nurses that come and they're going to ask me a bunch of questions. I mean, I'm not suicidal, but I guess they just do that so they don't have a problem and you have you under observation, you know? I understand why they do it, but I told the sergeant to put me in here. I said, if you keep me in here long, I'm going to go fucking crazy. Like,
they'll let you go back. They'll see you're okay. They'll let you go back.
Yeah, no, I'm fine. Listen, I woke up in jail. I'm back in jail. I've been here for a year and a half. I guess I was very big swing of emotions to go from like thinking you're getting out.
I know. We were all set.
Yeah.
It took a whole bunch of clothes from a couple of weeks ago. I packed up a suitcase for you, so that when you came, I had it ready for you to go to a hotel with it. And I had everything ready for you. We were sure you were coming out.
I didn't, honestly, the way I've been to Tallahassee for a year and a half, I could tell the temperature up here. I could tell how everybody knew who I was. This was not a case that this was not a normal case that goes through the system. This was a special case.
I know, honey.
Yeah.
It's a special case because everybody knows how rich this guy is who's coming in, right? I'm thinking, this is a good business opportunity. There's a need for the prisoners to know about the case. They're thinking, yeah, exploitation.
This was not. I said it. And I knew it. And I knew I should have. I knew what they wanted to do. You know, I stayed. And I saw it coming. I saw the freight train coming. I'll be fine. That's what I can say. I'll be fine. Gotta be strong.
You gotta be strong.
Yeah. Just like the stars. That's what it's doing,
Charlie.
What's that?
I'm saying we'll try to do everything we can to help you.
Don't give up, Charlie.
No, I'm not giving it up. I just listen. This was Tallahassee Super Bowl, and but when I sat, it's funny. I was so optimistic and everything. When I sat this morning and I saw what she was doing to close, and I kept writing down notes like she's lying. Like she's lying. Like she's making shit up. Like she's making issues of things that are not related to anything. It's not even evidence. They're just saying it's circumstantial evidence that I called my parents' home phone number. Like, and they put together an impressive pie chart that attempts,
How's that not relevant, Charlie? It shows that you were suspicious that your phone had been tapped by the FBI, which speaks to consciousness of guilt. It's not difficult to understand why that's relevant. Hey, let me call you back on a landline. They've had the same number since 1979. Georgia, stop making mole mountains or whatever. Stop making mole hills.
The 10th grader could figure out there's something special about it. But she made it out to be special. Everything was special. Everything was boom, boom. You know, Wendy's book that she wrote became like, you know, Wendy's putting down Tallahassee. Wendy never put down Tallahassee in her book, but she kind of spun on to be like, you know, the way Wendy looks at Tallahassee, like it was like Wendy was putting down Tallahassee. She wasn't putting down Tallahassee in her book, but it's the way it was. You know, you take the text, and you take the email, and you take the book, put some more pictures of emails up, and you like, you got the show.
I know. Believe me.
And I'm sitting there and watching the show, and you know, at the end of the show, she's quoting Ryan Fitzpatrick, who I didn't know in 2014, giving information on 2014, and I'm like, what the fuck am I watching? Like, I spoke to the guy twice in 2014. He was my best friend in 14, evidently.
Evidently. I know, I heard it.
Like, I'm like he was my best friend in 14. And then they say, listen, whatever the thing that he gave instructions, and he told me, like, whatever the prosecutor says or the defense attorney says in closing is not to be construed as evidence. It's not presented as evidence. They're just summarizing things in the case. You got to listen to what you heard during the trial. It doesn't go like that. These people just look and listen to the closing, and the way everything was like spun at the closing, I was like, this isn't reality. And these people are watching this. This is not reality, but they had a 2-hour production.
Yeah, she lied. She lied several times. I know.
You know, each person's, you know, has their own. It's like everybody who walks in has their own agenda, or you know, or a bone to pick, or a tail to spin, and everything just gets taken.
They've got their own agenda, or a bone to pick, or a tail to spin, or what other things could we do? A score to settle. Come on, anybody in comments, what else could it be? How long could this... Can you imagine if he just went on and on and on? I mean, he might. We don't know. We've paused. Where would it end? They've got an agenda. They've got a bone to pick. They've got a tail to spin, a score to settle, what else could it be? You get the pattern. What is the pattern? A whistle to blow. I bet this could go on for ages, but no one's helping me, so we're at an end.
Yeah,
shame.
Face value. Like I feel like a fool for even thinking or letting people convince me that I was gonna have a shot. I really feel.
I let people convince me.
You know, they say, go if you've got insights that don't listen to anyone else. You hear me? Hello? Hello?
We've got the best custom members-only emoticons in the business, right? Who else has got the face of a chocolate Labrador? How great is that? Soap, you're getting too much attention. Look, there you are. 3 of you. What a nightmare that would be. Yes? You've been snoring, you've been drinking, you've been eating, and you've been plotting, haven't you? Your agenda. You've got a bone to pick and a score to settle. I don't remember. A light to shine. I really want to keep going. We should like build a fantastic Metrix poem out of these materials. That would be I think it would be a good exercise in linguistics.
Hello? Can you hear me? Hello? Hello?
The caller has hung up.
An axe to grind. Awesome. Thank you to, well, the person that said that. Next.
You couldn't hear me. I knew something was wrong.
Axe to grind.
No, I couldn't. Did you hear me saying hello, hello, hello?
No, not at all. Because I was
Bridge to burn. A bridge to burn. They've got a bridge to burn. They've got an axe to grind. They've got a score to settle. They've got a tail to spin. They've got a... What was it? I love this. I love this. A light to shine. A tune to whistle. A whistle to blow. And then you could connect them like that, right? A tune to whistle. A whistle to blow. A blow to... that, well, you know, then you run into a complete dead end, and you just have to move on.
Yeah, it just went quiet.
And the bars didn't go down on the phone.
Boom! Thank you so much for that super sticker, Hamster MC Hamster. Thank you. That is it's mighty kind. Mighty kind.
So you've got what? The same? They take your mattress and put it in another room?
Yeah, I rolled up my mattress and I got a blanket and it's just in another room.
I rolled up my mattress and I put it in my pocket because it's that goddamn thin. I don't even know why. You know, the metal frame of the bed is actually softer than the mattress.
No, but it's like a solitary cell. You know, it's got a camera in here. It's got glass. And it's just got a bed. You know, I don't have contact with anybody. Hopefully, people won't be home all night.
Different floor or same floor?
No, picture of my pod. You can't picture it, but there's like a concert. My pod's got, is it 2 stories? You know, it's got a second level.
Right.
So it's got a second level and then a first level. And then on the halfway to the bottom, there's a concrete wall. And then they have all the suicide on a quarter of the pod underneath all the cells up on top. So it's like set up just like the pod is, but it's got a whole wall that divides it, and then it's got there's 15 cells back here, 6 men, 6 women, and they got cameras in each one of them, and they have an office that sits and watches all the closed circuit cameras in each cell. And that's so there's a toilet, a sink, and it's got a bed, a slab. Rolled up my mattress and blanket, brought it in here, and it's you know, for tonight, and I'm sure 5:30 in the morning they're probably going to bring 5:30, 6 o'clock in the morning. You can the nurses for 6 o'clock. She probably come through at some point, check me out of it. Hopefully allow me to go back to the pod that I came from.
Yeah.
I'll be there for at least another 30 days, and then I'll be transferred. I just thought I was going to get, honestly, I thought I was going to get a fair shake, and I never, put it this way, I never thought I was going to get a fair shake. I got led to believe that I was going to get a fair shake, and I started to believe it myself. You know, I just...
Total price?
And I got a blanket.
The U-Haul that you are renting out?
Yes.
No, but it's like a...
I'm going to take a look.
It's like a solitary cell. You know,
May I have your phone number, please?
Got a camera in here.
I believe it's under 76 599-3447.
You know, I'll have contact with anybody. Hopefully, people won't be all night.
Different floor or
Maybe we're back. Can anyone hear us? Let us know if you can hear us. The damn computer just shut off. Just shut right off, and then it said, well, we got to authenticate your user, and it was a whole thing, but we're sorry. It was just a random technical difficulty. Will you forgive us? We hope that you will.
same floor?
No, a picture of my pod. Okay, picture.
Well, that's pretty cool that we can just come straight back in. Thanks for letting us know, Pi and Samara. Okay, so we can just come right back in, straight in, and that's great.
There's a concert. It's my podcast. Is there two?
So I don't think it was buffering earlier. I think it just we went offline. We just went right offline.
Storage. You know, it's got a second level.
Right.
So it's got a second level, and then a first level, and then on the halfway to the bottom, there's a concrete wall, and then they have on the suicide on the quarter.
There's a second level, and then there's a first level. Well, there's never a second level without there being a first level. Otherwise, the second level would just be called the first level. There's just things that these they've all got their unique kind of flawed idiosyncrasies. Charlie Adelson does stuff like that. Unnecessary, superfluous descriptions. There's the second level, and then underneath it, there's the first level. Yeah, that's implied by there being a second level. That's what Charlie does, one of the things he does. Donna also has a very special way to completely destroy the good written sense of the English language. Every single time. I could pick 6 words at random in a row, like one sentence. I could pick any one sentence written by Donna Adeslon, and there would be a glaring, obvious, huge error in every single one. Almost every single one. I'm confident that if I chose one at random, it would be likely that there would be a glaring error. And she's a school teacher. I mean, if anybody should have a handle on just grammar.
Pod underneath all the cells up on top. So it's like set up just like the pod is, but it's got a whole wall that divides it, and then it's got this 15 cells back here, 6 men, 6 women, and they got cameras in each one of them, and they have an office that sits and watches all the closed circuit cameras in each cell. And that's so there's a toilet, a sink, and it's got a bed, a slab, rolled up by mattress, like they brought it in here, and it's you know, for tonight, and I'm sure 5:30 in the morning they'll probably get ready. 5:30, 6 o'clock in the morning, you'll be in the nurses for 6 o'clock. I'm sure the chief will probably have her at some point, check me out of it. Hopefully allow me to go back to the pod that I came from.
Yeah.
I'll be there for at least another 30 days, and then I'll be transferred. I just thought I was going to get, honestly, I thought I was going to get a fair shake, and I never, put it this way, I never thought I was going to get a fair shake. I got led to believe that I was going to get a fair shake, and I
starting to believe it myself. You know,
Fair shake is another one he just repeats. I was given a fair shake. I knew I wouldn't get a fair shake. I was never gonna get a fair shake. I should have gone with my gut. And my gut told me I was not gonna get a fair shake.
You know, Dan is writing to me while we're talking, Charlie.
Yeah,
He said, hang in there, we're going to continue to fight.
He asked me if I know how to make a Cuban sandwich. He said, listen, I just stopped at the Metro Deli next to the courthouse, and on advice of the judge, ate 5 Cuban sandwiches, one after the other. So you got a recipe? Because I'm coming to your house.
Just stay with it. Not giving up on you, just wait.
I know. It's just.
And poor Dan Markel, right, would have died without ever knowing what a Cuban sandwich was like. It's got the milk and the meat, the cheese, and then the meat. Those sorts of, like, what is it? Like medallions of pork, right? And then those are just what, grilled or just lightly fried, right? Then you got the ham, and then that, I think it's the Swiss cheese. I'm not too sure, but and also the trick is the bread. You've got to have the right bread. Not a brioche, but I think there is a sweetness to it. Think like the hearty Italian from Subway, but a better version. You know? Something like that. And then what else is on it? Can we look it up? Can we just, I don't want to mislead the public. Cuban sandwich format. Yes, okay. So some people like to put them in the, what do you call it? What do you call it? You know, the grill where you press, like there's a lid and you press down. A George Foreman. It's basically like a George Foreman, but it's not lean or mean. But basically, I'm looking for a standout image so you can really get a good idea. Well, yeah, I mean, I guess that looks, it's just a strange angle for a sandwich. And for me, in this set, I'll show you. Cuba. For me, personally, there's too much ham there. The ham, it's disproportionate. There would just be mouthfuls of just ham. And that's not the point, is it? The point is the combination, the contrast, the crispness of the pork, the squeeziness of the cheese, the smoothness of the, what exactly is in it? We'll tell you. I'll tell you. This is it. This is exactly it. Okay, we've got buttered and toasted exterior. Doesn't say what kind of bread. Cuban roll. A Cuban roll. And then, okay, let's go from the bottom up. The base, Cuban roll. Start with the mustard. A single stroke of mustard. Don't go too heavy. No, I like a lot of mustard. Sliced pickles, fantastic idea. sliced lengthways, right? That's exactly what we want. Who does all this slicing in small round circles? No. Lengthway slices of pickles. Chunky, but not, not overwhelming. Sliced ham, not too much. And what is this? Shredded pork. Well, this isn't even accurate. This is not accurate. This is not original. All right, we'll come back to it if I can find it original. Don't listen to that. That was all wrong.
The big case from Tallahassee is not your normal case comes back on appeals and they let a guy go like that.
Yeah. Was he flying back to Miami?
He drove.
Oh, he drove.
I mean, I stayed around because I thought I would get a fair shake. But that's not what happened.
I know.
It's like I should have stayed around for this. This is not something like. I don't know how. I just don't know how Dan was so optimistic. He was very optimistic, which I appreciate. But
because the case was good, and he was good, and you were good. It was the jury, honey. It was just what you said.
There was no jury in Tallahassee that would have let me go. That was never going to happen. I mean, we were like outsiders up here. Let's put it that way. We were definitely outsiders and looked at as like people from another planet that shit on Tallahassee. When she started doing that whole thing about Wendy's book, I was like,
are you kidding me? I know. What does that have to do with anything?
Well, it paints the picture.
That's what she did.
Like, what are you doing? Why were emails a constant theme? You probably lost 80% of this. Listen, you never win. You have to get it. The best you do is, like one of the guards was saying to me, he goes, the best you're going to do is hang. You have to have unanimous. 12 people have to vote your way. I mean, you think you're going to get all 12 people to vote your way? You're crazy. Not up here. The best you do is hang. If you hang, then you do it. The best you do is hang. If you hang, you stay here. You stay until they retry it. And they get another bite of the apple.
Yeah.
These people fucking hated me. I mean, they looked at me like some guy that's making $5 million a year.
Yeah.
I wasn't.
I know you weren't. Well, they're not finished, this family. You're just the start.
Well, I know.
Look, there's nothing, as you know, there's nothing you can do right now. You get through the night, you'll see these people in the morning, you get back to your cell. I'm going on to secure a check that adds the money to the account, so we'll be okay. And you need commissary money too, right? Commissary and...
commissary, man. I probably hold off on that because I got commissary money. I just need to get all my shit I need away.
Well, check tomorrow and see what you have, and you'll tell me what to order for the eye care, okay?
Yeah, hold off until next weekend to order it. And then I think the first camp I get to, I don't think you can order commissary or something. We go a little bit without commissary. Trust me. Until I know it's safe for me to get stuff, I'm not gonna, wherever I go, until I know that it's safe, I'm not going to be ordering like I have, I have my own cell, my own badge.
You said you're going to probably go back to your own cell tomorrow, right? Charlie? Hello?
Yeah, sorry, the bars just went down for a second, I'm back.
Oh, yeah, I was going to say, I thought you'd get tomorrow you'll go back to your own cell, right? The private cell?
Yeah, I should. I'm going to be in Leon for
a month.
I'm going to be in Leon County at least for another month, because then they have sentencing, and then they'll move me after they do sentencing.
Yeah.
Like, I'm only going to be here for probably a month, and then they usually do sentencing, and then they usually move you like the following Tuesday, when the buses come. And they move you to like an intake center. You learn all the stuff like you have to do. Kind of like they keep it like military, how they want things done. And then from there, they'll tell me where they're going to ship it. Somewhere to pick apart. So last thing I need is for you guys to get sick of, because I don't really have much else.
You're going to be fine, Charlie.
Yeah.
I just need you to be okay. It'll be fine.
Yeah, no, I'm going to take a shot. I'm still in jail. I was in jail yesterday and in jail today. I'd be more comfortable if I was in my cell. I'd be more comfortable if I was around the people that I talk to.
Right.
Walk around the little rec deck area.
It's already 9:30. They'll put the lights out at 11, so hopefully you get to go to sleep. And
this time, well, I haven't had that.
They don't shut the lights off?
No, but I can honestly, I've gotten to the point I just put my head underneath the blanket, and then it's dark. I've got a sheet, and then I've got a thick blanket. So I do that, and then I can sleep.
Okay.
So I'm in here, and it's just pacing around. They don't shut the lights off. They got the cameras on you. Well, they have a guard sitting watching the cameras. So, I don't know. I just literally was really thinking I was getting out.
We all did. We all did.
That's
just a shock.
Like I came to believe I was getting out, but like the distributor in Tallahassee wasn't like the way everybody was reacting to everything. It was like everybody was drinking the Kool-Aid too much.
Yes, he did.
Yeah, they drank Kool-Aid. They drank all the Kool-Aid they could. That was the problem. It's fascinating, isn't it? What we're witnessing here is the attempt to keep hope elevated, right? In the face of it being just flawed, beyond flawed, dug down into a hope hole. That's where they are now. Trying to get it back, trying to climb the rope of hope, right? But it's not attached to anything, so it just falls down. They can't get out, but they're trying. But it's taking them longer than the average person, because they so hate losing that they don't even understand how they could. Right? They're like, hang on, no, lost. We don't do that. So even though we've lost now, we can still win if we pay? Or what? How much?
Kind of thing.
Yeah.
Like, should have trusted my gut.
I know.
Your
gut's always right.
People. Yeah. No, and then I have like, people convince me otherwise, and then I'm like, oh, okay. No, cool. Should have gone with my gut instinct. Like, it was so, trust me, it was so on, it was ridiculous. like my gut instinct was so on, but I didn't trust my gut. You know, like when we get it, like a good gut instinct. It's a good gut instinct.
Yeah, I know.
You know, I trust it. I knew when I was sitting eating sushi with Roman that last time that I was with him. Like when we all went to sushi in Weston.
Yeah.
Remember, you know what I'm talking about?
What was that? Oh,
I look at the pictures all the
This-
time. I know exactly what you're talking
Nah, but I can.
You see, this is like the Rainbow Room clue in the Miles Franklin episode in season 2 of Prison Break. He's like, meet me in the Rainbow Room. Go to the Rainbow Room. Do you remember that place where we took that picture? In the Rainbow Room? The FBI think that's the restaurant in New York. But then it cuts. And what the FBI don't know is that their daughter's bedroom is painted with a rainbow theme throughout, right? So when he says Rainbow Room, he's saying go to the daughter's bedroom. And when he says, do you remember that place where we took that picture by the window? And the FBI are thinking, okay, they go into the Rainbow Room and then they had their picture taken while sitting eating in the restaurant and they were by a window. But really, there's a photograph in the children's bedroom, the Rainbow Room. The photograph is them at the fun fair, which is really where he wants them to meet. It's genius. It was done so well. That place, the Rainbow Room. Go to the Rainbow Room. I think that's what they're doing here. That kind of that attempt at code.
I don't really have much else.
We're gonna be fine, Charlie.
Yeah.
I just need you to be okay. It'll be fine.
Yeah. No, I'm gonna stay the shot. I'm still in jail. I was in jail yesterday. I'm in jail today. I'd be more comfortable if I was in my cell.
I'm still in jail. I was in jail yesterday. I'm in jail today, so I'm comfortable in myself. In my cell. Did he say self or cell? I'm comfortable in my cell.
Right. I'm comfortable if I was around people that I talk to.
Right.
Walk around a little rec deck area.
It's already 9:30. They'll put the lights out at 11. So
yeah,
you get
that little room with the dominoes, with a box of dominoes, looks real good now, doesn't it?
Go to sleep. And
this time, well, I haven't had that.
They don't set the lights on.
No, but I can honestly, I've gotten to the point I just put my head underneath the blanket, and then it's dark. I've got a sheet, and then I've got a thick blanket. So I do that, and then I can sleep.
Okay.
So,
what does he want? A fucking medal for engineering or something? Hey, you know what I worked out how to do? Well, in my cell, they don't ever turn the light off. So what I worked out, because I've been in here a while, you get to know how things work. So what I've worked out how to do is I'll take my blanket and I'll pull it up over my head so it's dark under there. He's bragging about this. Yeah, what I worked out how to do. You gotta hear that again. I love that.
Right. Walk around a little rec deck area.
It's already 9:30. They'll put the lights out at 11. So you get to go to sleep. And
this time, well, I haven't had that.
They don't shut the lights off?
No, but I can honestly, I've gotten to the point I just put my head underneath the blanket, and then it's dark. I've got a sheet, and then I've got a thick blanket. So I do that, and then I.
Yeah. Wow.
So I'm in here, and it's just.
And it's good because when Donna gets to jail, she'll know how to do that too now.
Facing around.
She won't have to work that out. He's done the legwork.
You know, they don't shut the lights off. They got the cameras on you. Well, they have a guard sitting watching the cameras. I don't know. I just literally was really thinking I was getting out.
We all did. We all did.
That's what we all
Just a shock.
Like I came to believe I was getting out, but like the gun distributor in Tallahassee wasn't time. You know what I mean? It's just like the way everybody was reacting to everything. It was like everybody was drinking the Kool-Aid too much.
Yes, he did.
Yeah, I should have.
I know.
I would say trust your gut instinct.
Yeah.
Like, should have trusted my gut.
I know.
Instead of listening.
Your gut's always right.
People.
Your gut.
Yeah. No, and then I have like, you know, people convince me otherwise, and then I'm like, oh, okay. No, I'm cool. Should have gone with my gut instinct. Like, it was so, trust me, it was so on, it was ridiculous. Like, my gut instinct was so on, but I didn't trust my gut. You know? Like,
big problem.
That's when we get it. Have a good gut instinct. It's a good gut instinct.
Yeah, I know.
You know, I trust me. I knew when I was sitting eating sushi with Roman that last time that I was with him. Like when we all went to sushi in Weston. Yeah. Remember, you know what I'm talking about?
Yeah, I look at the pictures all the time. I know exactly what you're talking about.
Okay, hang on. This is the bit I really want to catch.
It was so on, it was ridiculous. Like my gut, it was so on, but I didn't trust my gut.
My gut feeling was so on. I love how he finds room to brag while being convicted of murder. Still, he's like, yeah, I knew it. Of course I do, because I always do, because my gut is on. Oh, it's amazing.
You know? Like, that's when we get it. Have a good gut instinct. It's a good gut instinct.
My good gut instinct.
I know.
You know, I trust me. I knew when I was sitting eating sushi with Roman that last time that I was with him. Like when we all went to.
I knew sitting eating sushi with Roman the last time I was with him. Okay. Well, I mean, when you were last with him, he was 3. I don't know. Maybe things are different now. I don't think I'd had sushi when I was 3. I mean, why not? Why not? That's excellent. I mean, sushi's pretty healthy. It's got fish and rice. To me, it just seems kind of funny to think of a 3-year-old eating some Well, not California rolls. We know he doesn't like those. He doesn't even count that as real sushi. He's like, only a cop would come to a sushi restaurant and order a California roll. He probably doesn't even know what sashimi is.
Sushi in Weston. Yeah.
I guess it's the wasabi idea that makes sushi, because I mean, I think wasabi is the best bit about sushi. In fact, sometimes I'll just have rice with wasabi, soy sauce, and those pickled gingers. Oh, those are nice. Yeah. So it's not all about the fish. It's about that little green hot mustard. That's the stuff. And that, I mean, that's a lot to take for a 3-year-old, right? The sinuses, they're not even developed yet. Not even beginning to develop. It's too much.
You know what I'm talking about?
Yeah, I look at the pictures all the time. I know exactly what you're talking about.
You know the video when I'm eating sashimi with him?
Yeah.
I knew it. I knew he was going to say sashimi. It's not enough just to talk sushi. You got to say, if you're a pro, there's like levels of sushi, isn't it? If you're a pro, you got to talk sashimi. Which is expensive. I guess that's the other element here, is that the 3-year-old doesn't need to eat a piece of fish that just is $40 for a mouthful. Okay? That's just been flown in first class from Japan. It's extravagant. When I was 3, I would be happy with half a banana, bruised, half a bruised banana. That's what we had, and I turned out just fine.
And I swear to God on my life, I knew when I was sitting there taking the video with him. I just did. That's what was going through my head. Wasn't enjoying the moment as much as I was thinking, like, this is on video. It's really kind of weird, like, the turtles. It's weird. It's almost like an out-of-body. I felt like it was out-of-body experience while I was doing that. You know what I'm saying? Like, it just...
I do. I was there with you.
Like, I was there, but I just felt like this was like I was literally cherishing every moment. More so than I should have been for you, especially with my kid.
Yeah.
That's all my head is just stressful.
I'm sure it's
I want you guys to take care of yourself, because I honestly don't have much else to manage my life with now, unless something happens to you guys.
I know.
So, like, you need to take something to relax. Like, take something to relax.
Yeah,
we will. So, you know what I mean?
I do, sweetie. Yeah. I do.
Yeah.
I know.
Well, I know we're going to figure out a lot of shit in the next couple of weeks anyway.
Right.
Today's not the day to figure stuff out.
Not today. No.
I'm honestly, I cried a little bit myself, but I'm more just like, bigger shock.
You're in shock. I know. You're in shock.
Okay, it's very...
We all are.
I just hope.
Yeah,
talking
What's
that?
I was just going to say.
Yeah.
just hang in there, please, because things might change.
No. Things can change, and miracles can happen.
That's right.
But it's number one in this case is that it has to get moved out of Tallahassee. I mean, it was an absolute joke when I was sitting there. Fucking, it was a spectacle. It was literally a spectacle. Out of the 152 people we had come in, 93 were honest enough to say that they already what they knew about the case and revealed their biased opinion. We had 5 people on the jury with law enforcement in their family.
With law enforcement in the family.
Yeah.
I think that's low for Tallahassee. How many people in chat right now? Let's do a percent. Do you have law enforcement in your family? Let's find out. Let's get some live stats. Do you have law enforcement in your family? Yes, no. Are there any other options? Maybe. Kinda. Mall cops don't count, okay? That little plastic badge notwithstanding. We're talking real law. We'll just put yes and no. Vote in the poll.
Like, I had a guy that was a 20-year sergeant in the Army and then retired in the post office 20 years. Or working.
Neither of those are law enforcement. 20 years sergeant in the Army and retired postal worker.
In the post office. 20-year sergeant.
Who delivered on Trescott, so he has to be struck. He's biased.
Like 20 years black sergeant in the United States Army. Like, you're not looking like how is this 60-year-old retired sergeant from the Army look at me? Like an alien, like an outsider. I mean, I was a total outsider up here. This was not. Nobody could have won this case up here. Let's put it that way. Not even. I mean, you think Dan could be that wrong?
You know.
Hi, Metrix. How's life? I don't know. I lost my car key, so I'm trying to work out how to do that. I've got a spare, but it doesn't. It hits the immobilizer, so that doesn't go anywhere right now. And it's poorly parked. I mean, that's not really poorly parked. It's a little bit close to a corner, but it's fine. So I had to take the engine control unit out and then fix the van and then take the fucking engine control unit and a key to the shop, and then they want to charge me 145 euros. Can you imagine? And all of that has been happening on the rainiest days of the year. Plus, I shouldn't even drive the van into the city because it's illegal. And goddamn cops are everywhere, so it's been a little stressful, but we're okay now. It's great to be here with you, Pearl. Thank you for asking.
I guess
you gotta have 12 people vote your way to get out.
Yeah, I know.
They didn't have one. They didn't have fucking one.
You could only make so many X's. That's the problem.
Yeah. Yeah. I mean, the X's that really need to be used.
It's funny, isn't it? We're talking 3-year-old sushi. Well, not 3-year-old sushi. Sushi for 3-year-olds. And can we get a picture of a baby up here? They got a baby on these icons, or I think I've seen one. Maybe even more than one. Where's the goddamn baby? I don't know. I'll put a carrot instead. The carrot is a child because they both start with C. our new target audience, the 3 to 6s, no swearing, and a free piece of sushi with every live stream.
Correct. It's Charlie a fair shake. Get him out of here. They used their 12 to get anybody that would have given me a fair shake. That they threw. I used my, sorry, they're 10. I used my 10 to get rid of people I needed to get rid of. You know, but I still don't, I mean, I know it's the system or whatever, but like, I still don't understand how they can be taking so many things that have nothing to do with the case, from like the whole phone number to email to people's statements who have like vendettas, like, and then like present them like, oh, this person said this person said this person said you're arrogant. I mean, he's so arrogant. He's so arrogant. What makes me arrogant? You know?
Well, listen to this call, son. You know, what makes me arrogant? They said I'm arrogant. They said I'm elitist.
Make a lot of money.
No, they're just trying to paint the picture.
Yeah.
Don't they know that we're above them in every possible way? And they call us arrogant. I don't get it.
You throw some adjectives. You know, you think you're untouchable. I never said I was untouchable. Someone described me as that. So now you can keep referring to me.
I never said I was untouchable. I said I'm never going to get caught. I said I'm completely out of reach. I said I'm safe behind all my layers of conspiracy. Okay? They twisted words. Never said I was untouchable. I said I was above the law. Okay? Get it right, Kappelman. God.
Okay. Well, you're painting me like that, and then you throw that adjective there, and then you spin it, and you come up with a fucking chart that shows that I call the whole phone number only, 99.8% of the time. I never call the whole phone number. What can you call it? It comes there its own line.
The prosecutor knows she threw in lies. She knows exactly what she did. She played games with a jury, and
she should be on trial. Kappelman should be on trial. Imagine that. Imagine how great that would be. Just mix the whole thing up, Stop saying, Mix the whole thing up so that Kappelman is the defendant, Rashbaum is the judge, Charlie is the defense counsel, lead defense counsel. God, this would be great. I hope I can have a weird dream like that. Where it's all mixed up. What else could we do? Who would be the prosecutor? Judge Everett. Or would that be too close to being the judge? Maybe Judge Everett should be the court reporter. That would be fantastic. Except they'd have to make him a box, specially made box to put him in. No. He could sit outside the box, obviously. Just in the well of the courtroom. Fantastic. Harvey Keitel was a court reporter, a stenographer for like 20 years or something. I don't know if it was that long. 10, at least 10, I think. Like quite a lengthy career. He sat, Harvey Keitel, Mr. White, Winston Wolfe, and other things. He was a stenographer. That was his job. Thousands of cases. He must have sat there typing really quickly. Harvey Keitel. And then he said, I think I'm going to be an actor. It'd be great if he got a role as a stenographer, wouldn't it? I mean, imagine that imagine that industry knowledge, professional experience that he could bring to the role.
Got it. Is that what you want?
And she's a Tallahassee person, and I'm not. Very simple. I just, you know what? Part of me is just mad at myself because I saw the freight train coming. I just.
Okay, so only 10% have yes, law enforcement in their family. But taking into account of the time of day, probably most of our viewers are Australians, which doesn't count because it's a continent of criminals. Right? Of course they don't have law enforcement in their family.
You know what I'm saying?
Convicts.
We know, Charlie. We know.
I know exactly what you saw.
So, Reed's taking the day off tomorrow at work. Sherry called in. They were fine with it, they understand. She's pretty upset.
Yeah, I know.
For a while.
I know.
Did you talk to her?
We've been texting back and forth. I couldn't talk. I didn't want to talk to anybody. Talk to you and talk to Dan. That's it. Yeah.
Maybe we need to even it out and flip the poll. Let's end that poll, and we'll do one just for the Australians. And the results will speak for themselves. Has someone in your family served time? There you go.
I want to talk to anybody else. But I texted, and I know. I understand. I know what happened with her.
So I didn't call her again. Really, yeah, that sucks.
Yeah, both it sucks.
Like, it's not even. I just don't want you guys to get sick over it.
We'll be okay, Charlie.
Try to keep it together, Charlie. We'll try.
Really, we'll try.
Do everything you can.
Yeah.
You haven't talked to Wendy at all, have you?
I told you, I'm only talking to you and Dan tonight. I don't want to talk to anybody else. I just can't.
Did you text with her at all?
I just texted, when the verdict came in.
2 Australian votes are in already. And both of them are yes.
That was it.
What?
Just when the verdict came in.
How was she?
What?
Very upset. She's very upset.
Period.
Yeah. For murder. And they got 13 years in Australia. And did they also get all of their salary back paid by the government when they were released? And an apology letter from the Prime Minister. A little medal. Now you're a real Australian.
Oh.
Yeah.
Yeah. What have we done in a while?
I love you so much, Charlie. Please, I love you.
Just be strong, okay? Just be strong.
Yeah.
And then we'll be okay.
No,
Yeah.
listen, I'll be strong.
And take a deep breath. Be strong. Take a deep breath, Charlie. Take a deep breath. I loved that in the Chris Watts interrogation where they come back in and Tammy hits him with it. They sort of circle around him. Graham's got this attitude. He's sort of throwing down the notepad and He's sitting down like he's in a huff, you know. Shut up, Metrix. I've identified the fact that I say, you know, at the end of everything, and it's destroying my soul. Yeah, he sits down. Tammy's like, Chris, it is completely clear that you were deceptive on the test. You did not pass the polygraph today. Chris is sitting there going, oh, I didn't lie to you on that test. I swear, I didn't lie on that test. And Graham takes control, just takes complete charge of the situation. He says, Chris, stop. Take a deep breath. And then he demonstrates it. Take a deep breath. I want you to take a deep breath right now. And he does. And he does shut up as well. It's brilliant. Solid. Those guys. I mean, not that Chris was challenging in any way. But they really gave him some fucking tactics. Some golly good gosh tactics.
Maybe call Bree again.
Yeah,
I don't even know if I want to call Janice. I may call her for 2 minutes just to touch base, but that's it.
Yeah. If Bree's still up, I know she'll call you. I know she'll talk to you.
I may talk to Janice for a few minutes. I don't really.
If you don't feel like yourself, that's all.
Yeah, I'll call her. I can call her today.
Okay.
Thanks for you. I really thought I was going to get out.
I know.
What else is going on?
That what you just said to me.
Yeah. Not much else. Huh?
Not much else. Not much else.
I'm that talent myself.
You talk to her and then try to put your head down and just take deep breaths, you know.
I'll be all right. Take one day at a time.
That's right. Yes, you will.
That's right, Charlie.
Hopefully I'll get to see you guys soon at some point.
I hope so too.
Yeah.
I hope so too.
No, I will. It'll be not as soon as I want it, but
we'll see you soon, Charlie. We'll talk every day. We'll see you soon.
I'll talk to you guys every day and just, my priorities is I just want to take care of Roman as best I can.
We'll make sure that happens. And have faith, because there's a chance that this is going to change. So just have faith, okay?
Yeah, no, I do. And listen, you never know.
You never know. Could be. Could be a way out. Maybe. Time will tell. You never know. I think being proactive might, go a ways to being useful.
It has, in order for it to change, it definitely has to leave the out of Tallahassee. The jury selection was a sham.
It was a sham, actually. It was a sham.
It was a sham, and put it this way, if I would have known that she was going to be able to do what she was doing with, making the case about text messages and emails, and Jeff McCall statements, and Ryan Fitzpatrick statements, and, make a whole.
It's Lacasse. I've never understood why people struggle with this. In court, on YouTube. It's not Lacasse or Lacoste. It's Lacasse. I mean, he says it. He's testified 4 times saying his name each and every time. And the interviews. I think the best resource for how to pronounce his name would be him.
Jesus.
I mean,
I did not think
the lying was so obvious. I don't understand why they couldn't see it. It was blatant.
Well, it's not that. I mean, look, you should go to book.
Well,
You think any?
that's true if you're talking about Charlie. Katie was always broke. And what does he say? I thought she was protecting me.
Went on there has read a book in the last year. But I didn't even read his book, but like how many people in that? I mean, like someone writes a book. I mean, what she say in the book. I mean, she was putting down Tallahassee in her book. She was foreshadowing some place that they were stuck in. Like, yeah, right. If you took out 90% of what she was saying was just utter fluff. Like, it was just painting a picture. Painting a picture. I mean, you trust me, this was not, she wasn't putting on a trial, she was putting on a show. You know, I mean, I thought it was going to be more fact-based than like show-making.
Yeah, only one side had facts, the other side was just blatant nonsense and lies. Yeah, that's evidence.
What about the text message where I said there's 5 reasons why Wendy shouldn't buy a house in Tallahassee? How about the one is that a house is a pain in the ass? And there's constant maintenance. How about 2? I bought my house appreciated in value by 50% by the second year I owned it. Like, I mean, there's 5 reasons. They made it out to be like, aha.
That's funny to hear, isn't it? His house depreciated in value 50% the second year he owned it. Yeah, I'd call that getting stitched up, getting ripped off, right?
It's just like, they didn't look at anything.
I'm sorry?
They didn't look at anything that they had to be honest. It was nothing.
I mean, it's really a sinful. He presented well. He did a great job. I mean, there's no complaints on that part at all. Nothing.
No, I know he worked hard. There's no doubt. This was a case he was never going to be more than Tallahassee. Never was this case going to be more than Tallahassee. That's the only thing I can tell you that's positive. 100% positive. I just kind of, I didn't expect that from the prosecution. You know,
no,
I thought it was all a show.
It's such a joke with no evidence what she could pull off. It's just because that's what they wanted. That's what they wanted.
Well, listen, they painted a picture, and people hated you from the picture they painted, and it made the rest very easy.
Shameful.
Look, the number one thing I can't have is you guys get sick.
I promise. I promise we'll be okay.
I'll be well enough to stand my own trial in about 1.5 years.
Take AstraZeneca, take a deep breath,
yes.
relax,
done. And it's not worth it to take a little less. You might as well take a little more and just try to relax.
We will. We will.
Yeah, I love you guys very much.
I love you very much.
I love you too, Charlie. You know, I've always loved you. I've always loved you.
We'll take care of this, Charlie. Work through it, okay?
Yeah, I'm staying strong. I'll be fine. Stay strong. I'll be good. I'm getting myself tomorrow. Move around a little bit.
Okay.
I'll be all right.
Okay.
I'll tell her just to give you guys a few days before you come.
I didn't hear you. I'm sorry.
I'll tell Janet that you'll call her at the end of the week.
Yeah.
So you guys feel a little bit out right now.
Yeah. Okay.
Okay.
I love you, sweetheart.
Love you, Charlie.
We'll talk tomorrow, okay?
All right. I love you a lot. Have a good night, okay?
I love you, Charlie.
All right.
Good night.
Love you too. Love you guys. Have a good night. All right. All right. Bye, guys.
Bye.
The caller has hung up.
Hey, guys.
Hey, honey. I
Charlie.
just
Hey.
added that $100, so it should show up on your
Oh, okay. I just didn't know if you did because I called Janet and said you got $10. So if it doesn't show up tonight, it'll show up tomorrow. That's fine. I just wanted to remind you because I thought maybe you forgot because you were home today.
Oh no! I just did it literally as we hung up.
Okay.
Yeah.
That's cool. It'll be on there at some point. So.
Yeah. If it doesn't show, I mean, they already sent me. Let's see. They already sent. Let me see if the confirmation is through.
No, don't worry. I'm sure you did. I can always call you collect.
I have a lot of money on mine, so call collect. But I just got the confirmation, so it did go through.
Okay.
All right, honey.
All right. Listen, I love you guys a lot. Take an extra Xanax and just relax, okay?
We will, honey.
We will.
We will.
I love you.
I'll call you tomorrow. You guys have a good night, okay?
We will.
Call me call us anytime,
Okay.
please.
Love you.
All right. Love you guys. Take care.
Okay.
All right. Bye.
The caller has hung up.
Thank you for watching. Please like, subscribe, and turn on.
Please do like, subscribe, and turn on notifications. And get merch as well. Always get merch. Mugs and hoodies. So, what was that? That was this one. No. That's long. How long have we been streaming? 4 hours and 34 minutes. Is that long enough? It's probably long enough. I think we should probably end. Will we be coming back to jailhouse calls? Maybe. Why don't we have a look at Jeff? Jeff on the panel.
I want to thank everyone for this invitation to this distinguished panel. I'm very happy to be here. So for my one PowerPoint slide, I wanted to broaden out a little bit and talk about the upstream.
It's very blue, isn't it? Blue eyes, blue glasses, blue jacket, blue tie. Even his hair looks like it's got hints of blue through it.
Influences that lead to antidepressant prescribing in the first place. Many of the other panelists have mentioned in our conversations that frequently A patient will show up who's been on SSRI for years and is pregnant, and now is the first time for the conversation, which is almost too late, in some cases at least, and presents real dilemmas. So I wanted to talk about the upstream forces causing and at least contributing to that antidepressant prescribing, which is often 5, 10, 15 years before that conversation with the OBGYN. This is an image from a 2005 PLOS Medicine article that Jonathan Liu and I published about the chemical imbalance theory of depression, the serotonin deficiency theory of depression, which has been marketed by industry for a very, very long time, definitely since the introduction of Prozac, perhaps before, marketed directly to physicians for a very long time, and marketed directly to the American public through the direct-to-consumer advertisements, the Zoloft ad being the most famous one, being one of the most successful advertising campaigns in the direct-to-consumer advertising realm. In fact, 15, 18 years after it last aired, Saturday Night Live ran a recent parody that looks like a parody of a Zoloft commercial that's from almost 20 years ago. And that's the degree to which this bioreductionistic theory that depression, anxiety, PTSD come from a deficiency of a neurotransmitter, and that an antidepressant such as an SSRI will correct that chemical imbalance. That's the degree to which that story continues to be pervasive in our society. But Adam used the word disruption of the serotonergic system, and all the effects may be interpreted as positive in many instances. That's probably a more accurate term for what the SSRIs actually do. Now, these advertisements you don't see anymore, and perhaps FDA deserves some credit. From between 2007 to 2009, they disappeared. I don't know that we can put the serotonergic toothpaste back in the tube. I don't doubt that in university clinics or in elite practice scenarios that patients are not being told this story. But I teach MSW students, young women, and every single semester, I'm waiting for the semester actually, where someone doesn't raise their hand and say, I started an SSRI based on this theory, which I was told was a fact by my physician. And it was very recent. In fact, I've noted no change in the last 20 years in the prevalence of people reporting this story. And I wonder if this was just my own anecdotal experience. Just completed, it's an unpublished research project, but data collection is complete. And we did a survey of 1,100 Americans with quota sampling for about 10 different demographics, pretty nationally representative survey. True or false, depression can be caused by an imbalance of neurotransmitters in the brain, such as serotonin or dopamine. Antidepressant drugs, such as Prozac or Zoloft, help correct these imbalances. 88% say yes as of last May. Of the women of childbearing age, 18 to 44, who were diagnosed or treated for depression, 48% were told by their provider that a chemical imbalance was one of the explanations for their problems. In that same group, 63% were offered meds, 43% offered therapy, 40% lifestyle changes. Now, these are self-reports. More research is needed. Always replications are good. But the reputation of these drugs, the social reputation of these drugs as normalizing agents, akin to giving vitamin C in a case of scurvy, basically, is essentially a promotional message that our entire society has adopted. And that conceptually raises the impression of positive efficacy, and it also perhaps minimizes the recognition of adverse effects, because a normalizing agent shouldn't cause adverse effects, right? The Royal College of Psychiatrists in the UK has issued a statement about the chemical imbalance theory. It's not perfect, but it certainly has some humility to it and is something to look at. The American Psychiatric Association has been mostly absent from this conversation. I think FDA could partner with NIH or related partner agencies to remedy this information problem, which has not been solved and remains a pervasive issue.
Well, thank you, Mr. Lacasse, Professor Lacasse. We got anything else? No. What is this? Just checking if We'll shut it off. We'll shut it all off. Okay? It's a good time. It's a good time to cut off. Otherwise, the stream just gets too long, right? People look at it and they go, yeah, I love True Crime Metrix. I don't know if I got 5 hours to give him. And then they don't click. But you must click. You all must click a like button. Did we get 100%? We better. How do we receive that information? We click this. Okay, I'm gonna like the video as well. That's fantastic. 70 likes. Fantastic. That's what I do it for, you know. Likes. And glory. The more glory, the better. Okay, thank you for coming and moderating and being members and being chatters and being super sticker givers. And thank you to our supporters and our moderators. And thank you to everybody on Discord. Okay, we will be back. Let's hit the weekend running with another great Metrix episode on Friday. That's what'll be happening. We don't know what. We're not going to say. We're not even going to tell you what time. But we will try and put up a notification as early as possible. So keep an eye out for that. Make sure you turn on those notifications, like Charlie turned on his gut and should have listened. What's your gut telling you? Is it saying, click the like button? Is it saying, I should definitely subscribe to Metrix? Listen to your gut and have a great day. Have a great evening. Thank you, everybody. Have a safe journey on your way home. Wear a belt.